Good evening. Today is October 8th, 2025. We will be meeting in room 255 at approximately 6 p.m. for a standing committee on justice, chairperson to be announced. Thank you very much and have a nice night.
Good evening. Will the Standing Committee on Justice please come to order? Before the committee can proceed with the business before it, it must elect a chairperson. Are there any nominations? Minister Schmidt?
Thank you. I nominate MLA Oxenham.
MLA Oxenham has been nominated. Are there any other nominations? Oh, sorry.
Oh, I'm so sorry. Okay. I'll nominate.
Sorry. Minister Cable.
I'll nominate MLA Corbett.
MLA Corbett has been nominated. Are there any other nominations? Hearing no other nominations, MLA Corbett, will you please take the chair? Oh, my apologies. That's right. Sorry. Minister Schmidt.
Thank you. I withdraw my nomination.
Thank you. Mr. Oxenham name has been withdrawn as a nomination for chair. MLA Corbett, will you please take the chair?
Our next item of business is the election of a vice chairperson. Are there any nominations? Minister Cable.
I'll nominate MLA Oxenham.
Hearing no other nominations. Mr. Oxenham has been nominated. Are there any other nominations? Hearing no other nominations, Mr. Oxenham is elected to vice chairperson. This meeting has been called to consider the following bills. Bill number 8, the Liquor, Gaming, and Cannabis Control Amendment Act. Bill number 12, the Housing and Renewal Corporation Amendment Act. Bill 23, the Public Interest Expression Defense Act. Bill number 30, the Election Financing Amendment and Elections Amendment Act. Bill number 40, an act respecting O Canada and other observances and land and treaty acknowledgements in schools. Education Administration Act and Public Schools Act amended. I would like to inform all in attendance of the provisions in our rules regarding the hour of adjournment. A standing committee is to consider a bill must not sit past midnight, to hear public presentations, or to consider clause by clause of a bill, except by unanimous consent of the committee. Written submissions from the following persons have been received and distributed to committee members. Erna Buffy, private citizen on Bill 23. Brent Bjorklund, Manitoba Green Party on Bill 23. Kat M. Gauthier, private citizen on Bill 23. James Wilt, private citizen on Bill 23. Ben McGilvery, private citizen on Bill 40. Does the committee agree to have these documents appear in the Hansard transcript of this meeting? Agreed? Agreed and so ordered. Public presentation guidelines. Prior to proceeding with public presentations, I would like to advise members of the public regarding the process for speaking in a committee. In accordance with our rules, a time limit of 10 minutes has been allotted for presentations, with another 5 minutes allotted for questions from committee members. Questions shall not exceed 45 seconds in length, with no time limit for answers. Questions may be addressed to presenters in the following rotation. First, the minister sponsoring the bill, or another member of their caucus. Second, a member of the official opposition. And third, an independent member. If a presenter is not in attendance when their name is called, they will be dropped to the bottom of the list. If the presenter is not in attendance when their name is called a second time, they will be removed from the presenters list. The proceedings of our meetings are recorded in order to provide a verbatim transcript. Each time someone wishes to speak, whether it be an MLA or a presenter, I first have to say the person's name. This is the signal for the Hansard recorder to turn the mics on and off. Order of presentations. On the topic of determining the order of public presentations, I will also note that have in-person, out-of-town presenters registered, marked with an asterisk on the list. With these considerations in mind then, in what order does the committee wish to hear the presentations? Mr. Oxenham?
Thank you, Honourable Chair. I suggest that we begin with Bill 40. and have out-of-town presenters go afterwards.
Thank you. We will now proceed.
Sorry.
Oh,
Out of town or in person out of town?
out of town or in person out of town? Okay. Thank you for your patience. We will now proceed with the public presentations. So, a bit of 40.
Yeah, so go
I will now call on David Grant. David Grant, please proceed with your presentation.
Thank you. I'll be brief. It is good to begin each day with inspiring words, whether it's at school or at work. If those words teach us our shared history, that's even better. So this bill will ask school divisions to create policies. And if the policy goes beyond what we hear at City Hall, that would be even better. I believe these words should go beyond this used to be somebody else's land. They should explain the purpose and effect of our treaties. The schools have an opportunity to do that, as well as the usual acknowledgement. There could be 20 words explaining some aspect of treaties that could be of use, because if you see 1,000 starts to a school day and all they say is Cree and Anishinaabe, etc., it becomes somewhat meaningless, and the whole purpose is to teach why we have treaties, what the treaties were intended for then, and what they're useful for. So the bill is going that way, and maybe school divisions will add words of clarity and words of education to that function. And then the other part, Remembrance Day. I'm old, and I remember when Remembrance Day was celebrated in school at 11 o'clock. We went to the gym for an assembly. Now that it's a stat holiday, I think kids are losing a lot of the gravity of the day and the time. We can't make it not a stat holiday, so this bill goes through and says there shall be something between the 4th and the 10th, which is a start. But it sure would be better if we were back and had some other stat holiday added and had the 11th as a somber day for students to appreciate. And in the old days, every kid got to hear the remembrance. They got to hear a speech, sometimes from Ottawa, whatever. And now I doubt that 5% of them actually take part in the somber day. So that's just whining from an old man, but that's how I looked at it. And one of the other ironic ones, my wife is Ojibwe, and quite often City Hall either ignores the word entirely or bungles it with some other word. And that's the sort of thing where if the board is going to have a written policy and a written statement, we can agree on what the words used are, so they don't leave out an important group. There are more Cree here than Ojibwe, but that's beside the point. Anyway, thank you very much for the opportunity, and if you have any questions, I'm willing to take them. Thanks.
Thank you for your presentation. Do members of the committee have questions for the presenter? Minister Schmidt.
Thank you, Honorable Chair. Thank you, Mr. Grant, very much for your presentation here tonight and for your comments and for taking time out of your schedule to come down and participate in the democratic process. I appreciate it very, very much. I appreciated your expressions of support for Bill 40. I agree when we were talking about, you mentioned Remembrance Day and the need to make sure that it's observed more meaningfully. And so I think that the amendments in this bill do exactly that. They allow for more flexibility, to allow for greater participation and more meaningful participation in Remembrance Day services. And I agree with you that perhaps now more than ever, that's a very important time to take that time in the school day, in the school year, to help kids reflect on those lessons and on that history, and to respect and honor our veterans. So thank you very much for that. And I also wanted to make a comment. Am I running out of time? Clock. You spoke about the need for. Am I out of time?
45 seconds.
Okay, where's the clock?
It's in my hand.
Mr. Grant, would you like
In
to
rebuttal,
respond?
or complimentary, with this thing being formalized, hopefully on the 8th or 9th or so of November, what happens is something akin to what happened decades ago, where there's a gathering of students and they're led by someone telling some good stories. So we can hope for that, and again, thank you for the bill. Okay.
Mr. Uwasco?
Thanks, Mr. Grant, for coming and presenting and giving us your 2 cents on how everything sort of rolls and how it once rolled as well. So yes, I more than agree with you to make sure that the days of remembrance are put in there. And as the minister stated, she's put in there where there is a time of remembrance to basically give thanks to those that have gone before us and continue to fight for our freedoms. Just so you're aware, maybe, because I know that you're speaking at other committees as well, or other bill presentations, we are going to be bringing forward a couple amendments today in regards to the Royal Anthem and also...
Thank you for your time, Mr. Uwasco. Mr. Grant, would you like to respond?
No, thank you very much, Mr. Wasco. Okay.
Are there any other questions? Thank you for your presentation. We will now move on to the next bill. Now we're moving on to Bill 8. I would like to call on Kevin Reback from the Manitoba Federation of Labour.
He'll be dropped to the bottom of the list.
Mr. Reback will be dropped to the bottom of the list. I would like to now call upon Mr. Victor Vrishnik. Okay. Mr. Vrishnik will now be dropped to the bottom of the list. Mr. Grant, David Grant, would you like to comment? Please proceed with your presentation.
Only a few words. I note that it's really good that your bill summaries at the bottom on the website describes the important changes, so you don't have to read everything and compare it to the old version. So that part's good. It is missing the why. So we go to Bill 8, and it says you're going to do these things. It doesn't say what the motivation was. Is it because too many bars in a row is bad, or because a very successful place might have some parasitic place pop up right next to it, offering similar services? So, but otherwise, it seems like a good idea to have limitations on the concentration of bars or of licensed restaurants. On the other hand, there are no criteria listed, so this, in general, in law and in regulation of businesses, leaving too much to arbitrary opinion of a minister or of a civil servant is always a bit, I don't know, questionable. You know, people will raise questions as to, I applied for a license and you didn't give it to me because of the result of Bill 8. So that's the only downside I can see, is that somebody might consider it the denial of thing arbitrary. I don't drink, but I still support Bill 8, and I drive for Red Nose every year, and we like to get people home, and we've noticed that actually the bar and licensed restaurant business seems to be diminishing, that a lot of the places that we used to pick up people all evening long are closed at supper time. So I'm not sure that the need for this may have been greater a few years ago, but as far as the concentration of licensed places. But anyway, that was all, and thank you, and again, thanks for, looks like a good bill. Okay, any other comments?
Thank you for your presentation. Do members of committee have questions for the presenter? Minister Wiebe?
Yeah, thank you very much, Honorable Chair. And thank you, Mr. Grant, once again for your thoughtful presentation and your participation here in the democratic process. I think you're right that it's important for us to be clear about what legislation is about, and maybe not as clear in the explanatory note or in some of the details of the bill. We do have an opportunity at second reading, and we had some, chance in the House to share some of that. It's really about keeping kids safe, making sure that they're not around those who are getting served at a convenience store, rather than what would obviously be a restaurant or another licensed establishment. I also think that I think you made clear that it's important to have that clear direction and make sure that it's an even playing field, a level playing field, and that's really what this bill is about. Before I get cut off, thanks for your work with Operation Red Nose. You've mentioned that before. You're
Thank you, Minister.
doing really good work.
Thank you, Minister Weed. Mr. Grant?
Okay, well, thanks again.
Any questions from the opposition? Ms. Robbins?
I'd like to thank you, Mr. Grant, for speaking on this bill today. As MLA Matt Weeb, he did mention that it's to bring safety for the children, but we have them in rural Manitoba. So this rule is only set for urban areas, and I feel I am against this bill, because if you're saying that it's dangerous for the youth and the children in urban areas, it's got to be the same in rural areas. We can't split this. And it's happening in rural areas. We have them in hardware stores, convenience stores.
Thank you, Ms. Robbins. Your time is up. Thank you. Mr. Grant?
Thank you for pointing that out, and that is one of the problems with a province that is geographically largely rural, and a lot of the problems are shared, and the solutions aren't obvious where it's a very small agglomeration of buildings and not a city. So this is a start, and I share your concern. So thank you.
Thank you, Mr. Grant. Are there any further questions? No, seeing none, we will move on. Thank you. Is online. Ms. Sarah McIntyre? Or maybe.
So
Ms.
we would ask her to just turn on her microphone.
Ms. McIntyre, can you please turn on your microphone
And camera.
and camera? Thank you.
Hi.
Hi.
Thank you for having me. Thank you, Chairperson,
Thank
and
you.
congratulations on
Just
your
for a moment,
election.
please. So we'll now call on you, and Ms. McIntyre, can you please proceed with your presentation?
Okay, thank you. I'll be brief. I didn't realize I was presenting on this topic until a couple hours ago. My name is Sarah McIntyre. I'm the Vice President for Western Canada for the Convenience Industry Council of Canada, which is a mouthful, but basically it's the Convenience Store Industry Association. We have 1,000 stores across the country. Our industry employs close to 188,000 people in the country, and annually it's a $53 billion a year in sales industry. So even though we're little, we're pretty mighty. And I'll focus maybe more on Manitoba and where we are at as an industry in Manitoba. In 2020, we had 947 stores in Manitoba. And in 3 years, 100 stores have closed their doors permanently. So there's been a 100 store or nearly 10% reduction in the number of convenience stores in Manitoba, which is shocking. As we know, the Slurpee capital is Winnipeg. And we're an industry, unlike many others that present before committee. We probably have a member in each and every one of your ridings. These are community members, they're store operators, they're store owners, they're store managers, and they have a vested interest in the community doing well and and handling many restricted products. At convenience stores, we have gas, we have age-restricted products like cigarettes, and as an industry have always taken that responsibility very, very seriously. Even with respect to tobacco sales, I don't think that any one of our members has ever actually been fined for selling underage. Our membership profile, just to give you a bit more understanding of our members at the association, we have retailers like 7-Eleven, Couche-Tard. We also have vendor partners. Those are who sell in our store. They have products, the Coca-Colas, the Hershey's, the chips, as well as we have distributors, and those are our partners that distribute our products across all of our channels. So that just gives you a little idea of like who our industry is and what we're like in Manitoba. We have been facing a number of downward pressures as an association since the pandemic. Like everybody else, we really haven't seen foot traffic come back. Lots of people are ordering online, almost everything online these days. They're driving less because they're not having to be at the office for work. Contraband tobacco is a huge, huge issue for our industry. We've done some reports with Ernst & Young looking at the size of that market, and it's close to 50% of the market in Canada is actually illegal tobacco. So again, that doesn't bring people into the store, so that doesn't bring foot traffic in, and it doesn't bring sales. So there's lots of downward pressures on our industry, as you can imagine. And many of our members are trying to survive, trying not to be that 101 store that closes in Manitoba. And so we've seen some innovation in the product offering in different provinces. For example, in Ontario, we have beverage alcohol sales. So you were wondering when I was going to get back to the theme and the topic of the bill. Here we are, beverage alcohol sales in Ontario. We've got beer and wine sales have been in Quebec and beer in Newfoundland. We've got pilot projects in Alberta. And, ensuring our products are handled safely and in accordance with laws is very important. We have a program that we've developed as an industry association called ID Please, which we offer for free to all members, and it's to help to ensure that everyone is complying with age restrictions and age restricted products. And in fact, even in Ontario, where we had beverage alcohol sales now in the province for just over a year, we actually have our own beverage alcohol training program that was certified by the AGCO for training for the handling of sales of beverage alcohol. So this is not something new to our industry or our members or operators. They know that we are trusted. We're in your corner, usually your corner store, and handling these products is important to do that safely and to ensure members of all public are safe while we're while coming into a corner store. Also note, I think what we really need to do is to look at maybe some data and see, are individuals actually getting age-restricted products unlawfully at convenience stores? Our record for compliance is generally much, much higher than government-operated stores. So I'd like to see if there's some data in Manitoba that actually suggests that convenience store operators who are voters and small business owners in your communities are selling these products to underage individuals, which I would suggest that they're not. Most often, especially with other products that are age restricted, kids are getting things online. That's where they get everything. And, in Canada, unfortunately, there's something like 238 sites where you can get cigarettes and a whole host of other age-restricted products delivered to your house, usually by Canada Post, when they're not striking. So I think, from our perspective as an industry, we want to ensure sustainability for our stores. We don't want to see more stores closing. Like I have always said, convenience stores are kind of the canary in a coal mine, if you will. If you see a corner store closing, you're probably not going to go into that neighborhood at night. So we're here, we're partners, we're big tax collectors for government. We're here to try and find solutions that work for everybody. And, I think having this conversation about beverage alcohol sales at convenience stores is an important one, but I also think it's important to look at data and facts and to ensure that we're starting from a place where we can say, yeah, kids actually get booze from convenience stores, which is not the case. It's not been the case in any of our jurisdictions. And it's not in our interest to do that. It really is not. We want to be community partners and ensuring that we're complying. It's for everybody's in everybody's best interest to do so. So I'll just keep my comments to that and just say thank you for the time to hear our concerns, and I can take any questions.
Thank you. Minister Weed.
Yeah, thank you, Chair, and thank you, Ms. McIntyre, for participating in the committee here tonight. We had an opportunity to meet with some of your members over the last little while and hear from them specifically about the health of the industry, plans that they have for expansion, and so we're excited to work with them to make sure that we support the convenience store industry. I think that's an important part of the economic success that we're looking to build in the province. Just to be clear, what we're talking about here is not beverage alcohol sales as you characterize them. This is about service in a convenience store setting, so service in a restaurant configuration within an otherwise convenience store setting. So I think there is a distinction and something unique that's
Thank
here
you,
in
Minister
Manitoba.
Weed. Anyone from the opposition?
No, you got
sorry.
it.
Sorry. Ms. McIntyre, do you have a response?
Yeah, I get the distinction the minister is making, and I appreciate that. And it's one that we have in pilot projects in a number of other jurisdictions across the country. So we'd be eager to talk a little bit more detail about that.
Thank you. Ms. Robbins?
Thank you, Mrs. McIntyre, for your interest in this bill. And I have a question for convenience stores. Can you describe the kind of businesses that are currently licensed in Manitoba to sell alcohol with meals?
Ms. McIntyre?
To sell alcohol with meals? Like restaurants and sit-down locations? I'm not sure I understand the question. And maybe it's better to the minister.
Looking for clarification.
Just clarify.
Yeah, you just have to be recognized first and then, yeah.
Ms. Robbins?
The question is for convenience stores. Can you describe the kind of businesses that are currently in Manitoba serving alcohol or licensed to serve alcohol with meals in the convenience store?
Ms. McIntyre?
Sorry, thanks, Chair. Thank you, Chairperson. Yeah, I think you're referring to, there's a few pilots projects that a couple of our members are running with licenses that you could have beverage alcohol served to you by the convenience store employee if you're sitting down and having food with that purchase.
Thank you, Ms. McIntyre. Are there any further questions? Seeing none, we will carry on. And we will.
Sorry, before we go on.
We have had another written submission from Krista Bernas. Does the committee agree to have these documents appear in the Hansard transcript of this meeting?
For which bill?
Sorry, that's Bill 12.
For Bill 12, sorry. My apologies. Yep. Agreed? Agreed and so ordered.
I know, I just.
Sorry, Ms. McIntyre. Thank you for your time and enjoy the rest of your evening. We will now move on to Bill 23. We have some out-of-town speakers, so we will call on them first. So Shannon Hancock.
So Shannon, I have her on do my thing.
Shannon, can you please turn on your camera and microphone? Shannon, can you please turn on your camera and microphone? Shannon, we can't see your video. Can you please turn on your camera? There we go. Can you please, Shannon, can you please proceed with your presentation?
I will, and thank you very much, and thank you for considering this very important bill about public interest expression. I have lived experience as an individual who practiced for decades as a regulated health professional in Winnipeg. My voice was silenced following protected disclosures under the Workplace Safety and Health Act and the Public Interest Disclosure Act beginning in 2013. I was assured that I was protected against reprisal. I was not. As a regulated health professional, being unable to report health and safety issues that in my case were later validated by the Government of Manitoba Labour Board in 2018 and by Workplace Safety and Health in 2019, but required to continue practicing while effectively gagged under a non-disclosure agreement and settlement agreement between the Manitoba Nurses Union and the Winnipeg Regional Health Authority. It created a great deal of moral distress, conflicted directly with my professional and ethical obligations as a registered nurse. And it is a fact that public sector healthcare employers and bargaining agents for regulated nursing professionals are settling grievances by way of agreements that include oppressive non-disclosure agreements, one-sided releases, favoring employees that make union members vulnerable to reprisal. Regulated health professionals cannot practice while gagged, and it is to reinforce how that's happening. There are provisions in collective agreements between public sector healthcare employers, Winnipeg Regional Health Authority, Shared Health, Prairie Mountain Health, all the RHAs, and the Manitoba Nurses Union. This is the article that allows this to happen. Manitoba Nurses Union, Article 1311, nothing in this collective agreement shall preclude a nurse or, not and, or the union committee and the employer from mutually agreeing to settle a dispute by means other than those described in the grievance and arbitration procedures, or to extend any of the stipulated time limits. CUPE's agreement is even worse. CUPE Local 2348, those are the social services sectors, so the most vulnerable sectors, and the healthcare sectors. CUPE Local 500 Riverview. In their collective agreement, 1108, it says nothing in this agreement shall preclude settlement of a grievance by mutual agreement in any manner whatsoever. That contracts out of the contract. Those provisions are unconstitutional. They're resulting in settlement agreements between public sector healthcare and social services employers. and bargaining agents who just don't have equivalent bargaining power. The overwhelming majority of nurses, in my case, it was nurses, are women, female, members of marginalized groups. More than 90%, according to credible public sources, including the Canadian Institute of Health Information and the World Health Organization, to name just a few. Regulated nurses to this day, I know because I've been defending litigation because of an non-disclosure agreement between the WRHA and the Manitoba Nurses Union since 2014. And we're now finally have sought leave to appeal to this Supreme Court of Canada. This is a pressing issue in Manitoba. There's no place, zero place, for non-disclosure agreements between the Winnipeg Regional Health Authority, the Manitoba Nurses Union. Nurses cannot be intimidated, threatened, gagged, and forced to practice that way because that's a threat to public health and safety. If they can't report, patient safety suffers. So by having had this sort of legislation existed, and it should exist, I spoke a couple of years ago, actually, and I was assured parliamentary protection, and there were reprisals after. But I spoke to the issue of non-disclosure agreements between government reporting entities like the Winnipeg Regional Health Authority, Shared Health, and I'm not the only nurse who, another nurse was sued actually for a breach of an NDA right before I was, and I'm still in court defending it all these years later. The Manitoba Nurses Union was never served notice. They're a party to the agreement. So I guess what that means is the Manitoba Nurses Union is also gagged by the Winnipeg Regional Health Authority. And that situation is intolerable, can't stand. So any legislation that preserves the voice of somebody like me, like the nurse that you might see today if you or your loved one goes to the emergency room, they can't be under a gag order, and those gag orders can't be enforceable. In addition to violating provincial health and safety legislation and professional and ethical code of conduct, it's actually a violation of the Criminal Code of Canada. You can't intimidate, threaten, or interfere with a regulated professional or healthcare worker in the course of their duties. So please pass this bill or something like this bill to protect future generations. We have a critical shortage of nurses, and there's no way of knowing how many of them are practicing today under a gag order. Thank you for your time.
Thank you, Ms. Hancock. Are there any questions? Minister Wiebe?
Yeah, thank you, Ms. Hancock, for your presentation, and thank you for your work as a nurse. Obviously, we appreciate our healthcare workers so much, especially these days. So thank you so much for your work. I appreciate that you've had a chance to look at the bill. I do hope that the legislation that we're passing assists you without knowing some of the details about your case, but I do hope that it assists you in making sure that you feel protected. It's really about protecting the vulnerable. So thank you again for laying out some of your concerns and some of your support.
Ms. Hancock, do you have a response?
Yes, and thank you very much. I appreciate that. It's every little bit helps. And there's been a culture of, there's a lot, there's like parallel universes. There is the talk about transparency and accountability and safety and freedom, and health professionals can speak. And, then there's the reality of nurses who are practicing today under gag orders. And so I've been defending myself for all these years. And just because nobody wanted to challenge the practice of gag orders. So I got as far as the Court of Appeal, got obstructed there. So I'm now seeking leave to appeal to the Supreme Court of Canada. And I've actually served a copy of the notice on the Attorney General for Manitoba by way of Deputy Attorney General Jeremy Ackerstream. It's such an important issue, and every nurse in this Manitoba Nurses Union is not the voice for all nurses. It's the only voice you hear, but they are not the voice for all nurses. And their collective agreement is very different from the collective agreement for registered nurses on faculty at the University of Manitoba. They'll never be in this position because of the difference in their collective agreements and their collective bargaining power. MNU needs to revisit their collective agreements because a change to that provision would change the entire situation. You can't contract out of a contract. Again, thank you very much for your time. I don't want to belabor the issue or beat a dead horse, but I do appreciate your time.
Thank you. Any questions? Mr. Balkin?
Super. Well, thank you, Honorable Chair. It's a pleasure, and thank you, Ms. Hancock, for your presentation. It's very important process that we follow here to make sure that we get public engagement, and I appreciate everything that you brought forward. Having a wife that was a nurse, my mother-in-law is a nurse, and my daughter is now practicing as a nurse, I appreciate your candor and bringing this forward. Thank you.
Thank you. Any response?
Yes, thank you very much. And thank you to all the nurses in your family and to anybody who loves a nurse or needs a nurse. You don't ever want the nurse that answers your call bell at 2 a.m. to be under a gag order and sued and threatened by employers that are funded by government, which has been my experience for the last 10 years. So I'm here to change that, and that's the goal. Thank you again. And I hope you all have a good evening. Thank you.
Thank you. Are there any other questions? Seeing none, we will move on. Thank you, Ms. Hancock. We will now call upon MJ McCarron.
Yeah, I have them online.
Okay. MJ, could you please turn on your camera and microphone?
And also, I have handouts.
MJ, we're just passing out your papers. Okay, I would like to call upon MJ McCarron to start their presentation.
Hi, my name is MJ McCarron. I've been with Camp Morningstar for 6 years since its inception. I'm the only non-Aboriginal person or non-Indigenous person that is on the sort of the main committee and boards, and I do a lot of advocacy work on their behalf. I'm here today to ask you to protect, again, some of your most vulnerable citizens who are not always under the same protocols and sort of safety nets for speaking out provincially. And I want to back that up with some of the examples that we experience in Camp Morningstar that you may not be aware of. First of all, I want to be very, very clear that I am not blaming any individuals or criticizing any individuals. What I see is deficiencies in the various acts, one being the Indian Act, another one being the Mining Act, that set up adversarial relationships within the system. Often memorandums and other agreements are signed before the community is told, because under the Indian Act, there is no requirement to consult with the members of the band before signing such agreements. So what happens is that, you know, for us, we were not aware of the agreements until machinery started to move onto sacred territory. Immediately, you are criminalized. The RCMP set up an agency known as a division liaison team, and they send RCMP out to babysit you for however long they feel they need to be there to keep the peace. And I have to say, we had a very good relationship with the RCMP. We asked them to participate in ceremony. We conversed with them to keep the people there safe. We were not interested in being violent. We were a peaceful, sacred ceremony that whose main purpose was to be able to provide the information to the population that we felt was not being distributed. So let's get to some of the ways that people are kept quiet. First of all, again, you have the criminalization. The information is going one way. There's no two ways about it that the RCMP's job is to assess the situation and to collect intelligence. I don't have a problem with that because we weren't doing anything. And if you read the reports, if you get the reports under Freedom of Information Act, you can see that we were peaceful and they withdrew relatively quickly. However, within that document that I did give, there was mention of a possible BCR. So that's one instrument that, can be used to prevent, in that case, it was to prevent environmentalists from coming onto reserve land. And an effort to make sure that people were not getting the information they needed to make a meaningful decision. I also gave you another piece from the Yellowhead Institute, and on there is again going back to the way things are done and the way business is conducted. When benefit agreements are signed, we highly suspect that chiefs and councils are being instructed to, keep things secret until there is announcement. I've seen 3 or 4 agreements that have proceeded in that way and caught the population by surprise. But they also, I think, probably provide directives to, keep the band members in line, so to speak, if I can say that. Again, that's just an opinion. That's not necessarily a fact, but I found that the Yellowhead Institute article was quite good. When we started in 2019, freedom of expression was not a right on reserves. I was gobsmacked when I found that out because they weren't sure there were not enough freedom of speech cases, and there was not enough case law to determine whether that was effective and applied to band councils and to band council governments. And so, yes, under provincial and yes, under federal, you are guaranteed freedom of speech, but you weren't at that time. There's since been some cases, and so I would say that would proceed in a way that would be fair. But it's the whole point that you have to get involved in law in order to, or into the legal arguments in order to be able to speak out. Because of the involvement of the RCMP with us, there's consequences for the general public in speaking up. I would, under our current political situation, I wouldn't dare cross the border. And even if we didn't have the current political situation, I would be afraid of what those consequences might be, regardless of what my rights are as a citizen. We know that social media policies are being used to quiet people, especially on reserves. We know that, here's the one that, we live in rural areas, we live in isolated areas, we live in remote areas. We had 2 citizens of Hollow Water First Nation band. One was an environmental scientist. The other one was an engineer who could read through the documents because they're very technically dense. I can read some of it, but I can't interpret most of it to see how it's going to apply to, say, traditional ecological knowledge. They could, but because they worked for the government, they could not speak up, or they felt it was not safe to speak up. So again, this SLAP policy is really, really important because they were not be able to stand at the public meetings in front of their community and feel the freedom to speak. I think that is wrong. We don't have, a lot of citizens with that kind of educational background that can filter through things and know the land. And so for that reason, I wanted to make that point. The other point, again, there's systemic issues. Only the company speaks in consultation. So it's absolutely vital that we have citizens speak up and share their expertise and be able to tell us what they think of a company's plans. We did not come under any injunctions because the sacred fire was started before the company had a license. And then when they came back a second time, they no longer needed the land that we were on. So it worked out that way. We didn't have to experience that particular fight. But you can see that there's quite a few. One of our members was fired. We did take that. We did pursue that legally. We lost. We didn't have a lawyer. We couldn't afford one, and they won. But it set a tone. It certainly set a tone. And between the social policy, there was an educator whose job was threatened. They thought that, she shouldn't be participating in the sacred fire. They made calls to her principal. Luckily, the principal just said she's enjoying her constitutional rights. We're not going to take discipline, but they did kind of have a lockdown on social media, and you weren't allowed to research or mention the topic in the school until a 10-year-old trapper whose trapline was affected. She was 10 years old, marched into the vice principal's office and said, "This is our land. Why can't we talk about it?" And that's the thing, is that, we weren't violent. We weren't, we were just citizens who were standing up for what we believed in. Instead of being adversarial, why can we not sit and have conversations? And open up communication. So I'm begging you to consider this particular bill to allow, because sometimes, when all is said and done, the only way to get word out was either through the media or through organizations that represent our issues. And if they are slapped with, nuisance lawsuits, that's our last road to justice, discussion, meaningful conversations, and everything else. So I'm going to stop there. I think I've covered everything I wanted to say. But again, I'm leaving you with the idea that, this has come about because, our legislation is not favorable to public input to begin with.
Thank you, MJ. Do members of committee have questions for the presenter? Minister Wiebe?
Yeah, thank you very much, MJ McCarron. This is really, really appreciated that you're participating in the democratic process here, lending your voice in support of this piece of legislation. I think you, without knowing again all the details of the case, what I will say is that what you're talking about here is ultimately protection for the little guy, so to speak, and that's really what the bill's all about. So I really appreciate your participation here and giving us some perspective.
Thank you. Do you have a response, MJ?
No, I just, as I say, I think there are a lot of things that sort of go on that don't come to the attention of the public. So I appreciate this opportunity to share our kind of background and our experiences firsthand.
Thank you. Mr. Balkin?
Well, thank you, MJ, for that information and for providing that to us. And I think it's very important. I've said to many presenters at committee that we hear from people from Manitoba, people who have varying views and want to share that with the public. This is a very important avenue to do that. So I thank you for bringing this forward.
Thank you. Any response, MJ?
No.
Okay. Any further questions? Thank you for your time, MJ. We will move on. The next presenter is, and I apologize if I say your name wrong, Tanji Bell. Oh, phew. Okay, please proceed. Tanji, please proceed with your presentation.
Thank you. My name is Tanji Bell, and I am Chair of Our Line in the Sand, Manitoba. Thank you for this opportunity to speak on Bill 23, the much-needed Public Interest Expression Defense Act. Our Line in the Sand formed when a junior mining outfit proposed to mine directly in and operate over our pristine drinking water supply. Needless to say, if anti-SLAPP legislation was around at that time, it would have prevented threats and intimidation that have caused residents extreme duress and fear. For example, a concerned citizen posted pictures refuting company statements and received a cease and desist letter. An honest mistake of posting a draft ad for a public meeting prior to removing a logo resulted in the company writing letters, including one to the Environment Approvals Branch, who posted it to the public registry. Our response letter, explaining our position and questions, was not posted. Some residents who were members of Our Line in the Sand were further silenced when CO, then HD Minerals and CanWhite, had them sign NDA agreements. 2 municipal councillors who voted against the RM and CO Silica development agreement were also threatened with legal action by the company if they did not reverse their vote. Of course, such actions have a chilling effect on public participation, democracy, and cause much fear and anger. We were thoroughly disappointed when anti-SLAPP legislation, Bill 236, the Public Protection Act, introduced in 2023, was voted down by the previous government. So thank you for bringing this forward. We are in support of Bill 23. However, we do not support the addition of Section 4.2 of the bill, as we feel it does not provide the required protections for public participation. There should be an opportunity for all proceedings to be paused, even when injunctions are involved. In our opinion, this is an obvious and terrible loophole in the bill. A judge could dismiss the originating action or application, but motions for injunction relief would still be allowed to proceed. Keeping it in destroys the integrity of anti-SLAPP legislation, which is to protect discussion and open debate on matters of public interest, including holding our political representatives to account. As an example, our phone calls, letters, petitions regarding exposure to silica sand particulates from uncovered stockpiles were not acted on by our regulator. We had to block a road to have our concerns addressed. Our former municipal council made no real effort to help voice or act on our concerns. The November 16th, 2021 Carillon article, quote, former CanWhite employee alleges well contamination, lacks site safety, unquote, stated the former mayor, quote, wanted CanWhite to succeed. And CanWhite, as you know, is also known as HD Minerals and CO Silica. The Ethics Commissioner report clearly shows the lengths the former government went to have the project succeed. We were left with no other recourse than to set up a blockade. So this so-called public disorder to have our property rights, our livelihood and health protected was necessary. This protest also allowed us to have the greater community aware of what was happening to us and show that more than a few people were being negatively impacted. Capture of our government by industry development forces people to take action to protect themselves. Our antiquated environment and mineral legislation magnifies this need to take action. The system makes public disorder a necessary and, in our experience, a legitimate form of public participation. We had also contemplated another blockade when our water quality complaint with the water branch was dismissed as correspondence. Under Manitoba regulations, the branch is mandated to investigate complaints. Because of the threatening environment at that time and the lack of protections for citizen action, we did not proceed with the blockade. In our opinion, keeping Section 4.2 that establishes an exception for injunction proceedings destroys the integrity of this anti-SLAPP legislation and thus does not protect the public voice and does not protect the public from negative mental, emotional, spiritual, and financial duress and the demands of a legal battle. Passage of this bill as it stands will mean that the next time we need to hold a public protest, whether that be a blockade, to hold our government and or industry to account for hazardous materials or operations or bad water or on the steps of the hospital, we will continue to do so under threat of legal action. Our planet's climate is dangerously changing and biodiversity is in crisis. Our social and economic health too. We all have a role to play in safeguarding our public interest and the environment for future generations. The law should help us do this, not hinder us. Please remove Section 4.2 from Bill 23 and close this legal loophole that leaves Manitobans vulnerable to SLAPP suits from the wealthy and powerful through the use of injunctions. So thank you for this opportunity to share our concerns on Bill 23.
Thank you, Tanji. Mr. Minister Wiebe with questions?
Thank you, Chair. Thank you, Tanji, for your public advocacy and for presenting here tonight. Thanks for sharing some of the details of the ordeal. I think it helps us better understand the actual impact that it has on individuals and community, and I really take that to heart, so thank you for bringing that forward. Your comments on Section 4.2 are noted. They're appreciated, and we look forward to working with you in the future.
Do you have a response, Tanji?
Cool.
Thank you. Questions from the opposition? Mr. Balkin?
Yes. Well, thank you, Ms. Bill, for your presentation. Again, it's very important to hear many perspectives from Manitobans on these bills, and I appreciate what you brought forward. It gives us plenty to think about, so thank you.
Recognize.
Tanji?
Thank you.
Thank you. Any further questions? Minister Cable?
Hi. I just wanted to thank you for your bravery during this ordeal. I know that it couldn't have been easy, and with all of the political pressures you were facing with everything that was going on. So thank you for your steadfastness and for standing up for what's right.
It's democracy.
Tanji?
Whoops, sorry.
Yeah, no, it's all good. Tanji?
Thank you very much. It was not easy. That's why this bill is so necessary and a real bill. Take that Section 4.2 out, please. Thank you.
Thank you very much. Now we will move back to Bill 12, as that concludes our out-of-province, out-of-town guests. And the first person on the list is Fernanda Vallejo. I hope I said your name correctly. Fernanda?
Okay, so my name is Fernanda Vallejo from Latinas Manitoba, a nonprofit organization that helps immigrant women and families build new lives here in Manitoba. Housing is one of the biggest challenges we see every day. Many newcomers and single mothers face long waiting lists or poor housing conditions. Some are afraid to speak up because they don't understand the system or they are worried about their immigration status. I know this bill focuses on improving the governance of Manitoba housing, and I truly hope it will also improve access, maintenance, and communication with tenants. Landlords as well. Okay, so community organizations like ours can play an important role supporting, providing guidance to the community, to immigrants. But I hope this bill can be approved for all these situations, especially for the women that are facing domestic violence and they are in this waiting list. Thank you.
Thank you, Fernanda. Questions? Minister Smith?
Thank you, Honorable Chairperson. Thank you, Fernanda, for your presentation. And certainly this bill is meant to protect housing and keep housing within the portfolio of government. Any funding 15% or over is protected under this bill. We saw housing under Lyons Place be sold out, which made seniors vulnerable and rents go up. Seniors with fixed incomes, and we know that women that are fleeing domestic violence, such as you outlined, are also, facing financial hardship too, often with children, with families. They need, that kind of housing.
Thank you, Minister Smith.
Thank you.
Fernanda, do you have a response?
No, thank you.
Okay. Any questions from the opposition? Any question? Mr. Bariza?
Thank you, Honorable Chair. Thank you, Fernanda, for the presentation that you've done tonight. And we look forward to moving on with this bill.
Fernanda?
Sounds great. Thank you.
Thank you. Any further questions? Thank you. Sorry.
You'd have to ask for leave from the committee.
Can we ask for leave for the committee for Fernanda to continue? Agreed?
Little invitation. So the Latin American community, we are celebrating our heritage this month. And this October 15, we'll have a ceremony here at 5 p.m. I just would like to invite you, all of you.
Nice.
Okay, thank you.
Wonderful. Thank you. I will now call Erica Wiebe. Erica, please proceed with your presentation.
Hello, my name is Erica Wiebe. I'm here representing the Right to Housing Coalition, and I'm co-chair of a subgroup within the Right to Housing Coalition called the Seniors Working Group. So in January 2023, as already has been mentioned, Lyons Place, the largest nonprofit residence in Manitoba for seniors with low incomes, was sold to a private company based in Calgary whose stated goal is to maximize profit. And in effect, this meant the loss of 287 units of units for seniors with low incomes. And in 2018, 185 Smith Street, which housed over 300 social housing units, was sold to a private company, and there's now a high-end condominium building on that site. So together, the loss of these two buildings represents 600 less housing units for people with low incomes. At the same time, homelessness is something that we're all concerned about. It is at completely unacceptable levels in our province, and many more people than that also live in unsafe, precarious housing with no options to move because they can't afford to. So most Manitobans would agree that an important solution to this problem is much, much more supply of housing that's purposely built for people with low incomes. The Right to Housing Coalition estimates that 10,000 new units are needed. So in this context, it makes no sense that we should be okay with losing housing stock that already exists. So it's for that reason that the Right to Housing Coalition strongly supports legislation which puts limits on the sale, demolition, or change in use of non-market, social, and affordable housing. In fact, the Right to Housing Coalition advocated for this after the sale of Lyons Place. While Bill 12 is a positive step, we do have some recommendations that would strengthen the bill. We believe that now is the time to ensure that this legislation is as comprehensive and robust as is needed to achieve the goal of protecting existing and future non-market social and affordable housing. So first recommendation, In Bill 12, consent for the sale, demolition, or change of use of a funded building resides with Manitoba Housing and Renewal Corporation instead of, more appropriately, with the Minister of Housing, Addictions, and Homelessness, the latter who bears the responsibility and is accountable for the oversight of social and affordable housing in Manitoba. So we just think that the loss of any publicly funded housing is a serious matter with serious implications for the public, and therefore that decision should rest with the minister. Second, no buildings should be sold, demolished, or have a change in use unless there is a plan in place to replace the social and affordable housing units that are lost. So sometimes some housing complexes are no longer viable. There may be no choice but to demolish or sell. And in all instances where it is deemed necessary to sell, demolish, or change the use of a building, there should be an automatic concurrent development of a plan for how those lost units will be replaced. Third, buildings that receive operating agreement funding for services and/or rent supplements should be included in the legislation, as well as buildings whose funding agreements have expired. Government-owned housing should also be covered in the legislation. Again, the objective is to preserve and protect buildings that are a public asset where public funds have been invested. So we believe that the types of housing that are covered in the legislation should be broadened. And with regard to government-owned housing, so many people, as in the case of 185 Smith Street, so many people with low incomes rely on this resource for decent housing, and many, many more are on waiting lists to get into it. It should undergo the same scrutiny as other publicly funded housing. This is not about which party's more likely to preserve public housing when in power. It's about long-term practices, no matter who's in power. Number 4, if there is a sale of government-owned housing, all the proceeds of the sale should be reinvested back into the government-owned RGI, rent geared to income, housing envelope. It should not be reinvested into debt repayment or other areas of government. 5, Bill 12 should include protection for tenants in the case of a sale. So tenants must be fully informed, and alternative comparable housing, if possible, at the same rent must be secured for tenants in the case of a sale. So the Seniors Working Group, that's part of Right to Housing, includes people who lived at Lyons Place. So we had a firsthand look at the stress, the high levels of stress that were caused by housing uncertainty that this vulnerable population endured. So the government needs to ensure that tenants are taken care of in these situations. And that's it. Thank you very much.
Thank you, Erica. Questions? Minister Smith?
Thank you so much for that, Erica, and for all of the work that Right to Housing Coalition does. Certainly, we've worked on this legislation with your coalition, and the Lyons Place was certainly, what brought this legislation forward. We want to ensure that we're protecting, preserving the housing stock that we have, and ensuring that we keep safe and affordable housing affordable, and that we're protecting taxpayers' money, and that we don't have another Lyons Place occur under, in the future, and that this legislation protects it for future governments to come.
Thank you. Erica?
Yes, totally agree that we need it to be really strong and robust so that it can be long-lasting legislation that really benefits low-income people, low-income residents.
Mr. Bariza?
Ms. Weep, thank you so much for your presentation and for your recommendations.
Erica?
Thank you.
Okay. Any further questions? Seeing none, we thank you for your time. And I will now call Ms. Lynn Fernandez. Ms. Fernandez, please proceed with your presentation.
Good evening, everybody. Thank you for the opportunity to present on Bill 12. As a senior who volunteers with low-income seniors living in social housing, I'm in favor of Bill 12, the Housing and Renewal Corporation Amendment Act. There are, however, ways the legislation can be strengthened to protect tenants, ensure no further loss of social and affordable housing, and increase government accountability. The bill now excludes buildings whose funding agreements have expired. Given that the goal is to protect low-income renters from losing their housing, these buildings should be covered by the legislation. First and foremost, social housing, whether it be in the nonprofit or public sector, is designed to meet the needs of low-income, vulnerable communities. Indeed, this is a clearly stated mandate of the Manitoba Housing and Renewal Corporation, which works closely with the nonprofit housing sector. Taxpayers contribute revenue to maintain different types of funding for social housing, so protection of any of these investments should not be excluded. Accordingly, buildings that receive operating agreement funding for service and or rent supplements and buildings whose funding agreements have expired should be included in the legislation. Government-owned buildings should also be included. Given the extreme shortage of social housing in Manitoba, ensuring no loss of units should be top of mind. The sale of 185 Smith and Lyons Place removed over 600 units of social housing from the housing stock. I spoke with an individual who had to leave his home at 185 Smith. He moved to Lyons Place, believing he had a secure place to live, only to find out that it too had been sold. The province then had to provide rent supplements to tenants who were facing the higher rents charged by the private corporation. When the 2-year supplements were coming to an end, tenants were scared and anxious that they would not be renewed and that they would be faced with trying to find suitable accommodation that they could afford. Now, those supplements did come through, as we know, but the anxiety that the tenants faced before they came through was palpable, and this is something that Erica managed as well. We should not be forcing vulnerable seniors, many without family support, to deal with such a stressful situation. To this end, the legislation should stipulate that there be no net loss of social and affordable housing should a building be sold or demolished. Government-owned assets should be covered by this legislation, but in the event a publicly owned building has to be sold, the proceeds of the sale need to be directed to the social and affordable housing revenue stream. Sale proceeds should not be used for other government expenditures. Loss of social or affordable housing units has serious consequences on people's lives. The government of the day needs to be publicly accountable when a building is sold or demolished. So responsibility for a sale needs to rest clearly with the Minister of Housing so the public is aware of what's going on. And in the event a property has to be sold or demolished, tenants must be provided with suitable living accommodation for the same amount of rent. And a viable plan needs to be in place before approval and sale if the sale is granted by the minister. That's it. Thank you.
Thank you for your presentation. Any questions, Minister Smith?
Thank you, Lynn, for your presentation. And certainly this bill is meant to protect and keep affordable housing affordable and to ensure that Lyons Place, something like that, doesn't happen again. We feel that this strikes the right balance in ensuring that, there's more people developing affordable housing. We know that people that are developing affordable housing aren't in it to make money. Certainly they're in it to provide affordable housing. We see a lot of mixed market housing going up because we know that they also have to maintain the housing that they're building. So we love seeing those kind of models. We hear a lot of good feedback from folks that there's some mentorship happening in those models as well. So your recommendations are duly noted, and I want to thank you for the advocacy that you're doing. Thank you so much.
Thank you. Ms. Fernandez?
Yes, thank you, and I do believe you're right when you say that people who provide nonprofit housing are not in it to make money, but when they're not adequately supported, I mean, this is a bit of a tangent, but when they're not adequately supported by government so that they can maintain the units and the rent supplements, then there are for-profit organizations that are waiting in the wings to swoop down when these properties become available, and that's one of the things that we're concerned about and that we hope that this bill will protect.
Thank you, Ms. Fernandez. Mr. Bariza?
Thank you, Ms. Fernandez, for your presentation, and thank you for your recommendations.
Ms. Fernandez?
No, thank you.
Any further questions? Minister Cable?
Thank you for your presentation today and for the work that you've done for years and years and years to take care of our relatives. And thank you for coming with a presentation to remind all of us of the humanity in one another and our obligation to take care of our neighbors who maybe aren't the same or don't come from the same family circumstances, that there really is an obligation for us to consider the most vulnerable in society and to make sure that we keep them top of mind. And I can assure you that this government is doing that.
Thank you, Minister Cable. Thank you. Ms. Fernandez?
That's fine. I hope that that's going to be the case. We sincerely hope that this legislation will pass with these amendments, and so that it really is a strong protection for vulnerable people. Thank you.
Thank you, Ms. Fernandez. I would now like to call Gerald R. Brown. Gerald Brown.
You'll be dropped to the bottom of the list.
Mr. Brown will be dropped to the bottom of the list. I will now call Tom Sims. Tom, please proceed with your presentation.
Yeah, thanks for the opportunity. It's great to be able to speak. My MLA is here today, the Minister of Housing, Mr. Smith. Appreciate all the work you do for us in Point Douglas. I wanted to speak about things from more a personal context here. We're here with, political dynamics, and there's community dynamics, and there's a lot of stuff going on, right? But I really wanted to talk about it from a personal point of view, because I think in our community, our society, we all care about our elderly people. We care about our grandparents, our grandmothers. We care about older uncles and aunties and stuff like that. And so I think that transcends partisan lines. We care about that, right? But it's how we go about supporting that, I think, is an important thing. And I got to say, back in July of 2022, sitting at my place, minding my own business, and I get a call from my mother, who lives at Lyons Place, and she's lived there 25 years, right? And she turned 96 in June, that's a pretty good age, right? And she said, Tom, I got this note slipped under my door that they're going to sell the building. Middle of the night, a note comes under the door that they're going to sell a building that was home to many elderly people who are on more low and fixed incomes. And I got to say, that was a real feeling of powerlessness. Like, people's worlds were just shook. No notice, nothing, right? And like I say, there's a whole bunch of political dimensions, and definitely I'm not above that. But I want to just, trying to get this at a personal level. I think as a society, as a province, we care about older people. We have cultures, and First Nations, Indigenous cultures, important kind of acknowledgement of the role of elders in our community. And I want to keep it at that level for a bit. And so that was really a tough feeling, to feel so powerless that this was going to happen. I guess the other thing for me was that, as we started to learn about things, like I said, I'm sitting there at home minding my own business. I don't need to know all this stuff about housing options and all this kind of stuff. But, one of the things we saw, that Lyons Place was the largest nonprofit seniors housing facility in the province. It was a Cadillac. It was a Cadillac. And I guess the other thing I reflect on what Lions Place has become is we pulled together then, we didn't know what to do, but we pulled together a committee of family members and residents, right? And it really amazed me. Some of these residents, I thought this one guy, he's probably about 75 or something. He winds up being 85, who's very active in the committee. And this other guy, I thought, well, if this person's 85, this other person's probably the same age. He was 92. And we had to all band together to save the building. And I still remember that our first public protest. So we got all these people in wheelchairs and and walkers and everything, and we're standing outside of Smith Street Lofts. That's how we launched the campaign to save Lions Place. We're standing out there, and our message was, we don't want Lions Place to become the next Smith Street Lofts. That was our message. It's already happened. We don't want it to happen again. And I think one of the things that's very sad for me is now there just isn't Smith Street Lofts to stand out in front of. Now the community talks about, we don't want the next Lions Place to happen. I don't feel good about that. I don't feel good about being a precedent about, we don't want this to happen again, right? And so I guess, one of the things I think we really need to look at is what do our elderly and senior folks need, right? And as Erica talked about, I'll just focus on Lions Place. That's a loss of 300 units. And I'll talk to you about what it's like there now. We knew it was going to happen that way. We knew that Main Street would play the long game. So right now, it's only about 30% of the residents that are seniors in Lions Place. So we had the Cadillac building and all the province serving about 300 people. Now there's only 30% that are there now. And it's only going to go down further as people need to go to other places to live, as people people have really found that they're just living in an apartment block right now. It's not a senior's home. And this past month, I had to move my 96-year-old mother out of there. She'd been there 25 years. And it was her home. And I don't want to focus this on me because there's a lot of people who have a lot worse challenges, right? But I also want to bring some, what's the impact of these things on a personal level? And it just wasn't the place for seniors anymore. We worry about the amenities that were in there, the cafeteria and the store. The younger people don't use the cafeteria. The younger people don't need the store. The people who remain there do need it because there's a lot of seniors, number of seniors that live there that can't afford assisted living, and that meal is really important to them. That's what helps them hang in to a place that they really are struggling with. So, I think we need to think about, those kind of things. And like I say, I think that's a bipartisan issue. We care about seniors. But I think the previous government needs to understand that that was a colossal error and that that's a long-term legacy that has impacted a lot of families. And I just want to be, blunt that, I get it. There's a role for profit-driven housing in our community, but there's also an important role for nonprofit, non-market housing. And it doesn't have to be ideological. The numbers just don't add up. People can't afford the rents, and that we need to have a way of meeting the needs of folks like that. So that is a long-term impact on families. And I think we need to understand that there is an important role for nonprofit, what I would argue rent geared to income housing. So I do have a couple of things to say about the bill. When you're doing community work for a long time, you're like a history library that no one ever sees, because you have all these letters and emails and stuff like that. So I did dig up, because I had sort of a general recollection of where this idea for the government to intervene on the sale of housing came from. And so it was right in the midst of when Lions Housing had refused to put a pause on the sale and to allow the community and the three levels of government to come together to look at an option. And one of the things, I was going to include it in the package, but I just thought I'll wing it. But, one of the things that was really important at that time is one of the cabinet ministers from the federal government, Dan Vandel, sent a letter to the chair of Lions Place to say the federal government funded this program, this housing initiative. This is public money. We think it needs to remain a nonprofit housing entity, and we're willing to work with the community that wants to look at an alternative. Lions board refused any of those kind of options. And so we were left with needing to say, well, when buildings get sold, what do you do? So it's interesting, and this is why, I think it's a kudos to the public sector servants, is there was
Tom, I thank you for your comments. I do ask for leave for Tom to finish his final remarks. Is there leave? Agreed? Okay, please continue.
So it was a staff person connected with CMHC that was on our working group, and he shot us an email and said, look, there's legislation in Quebec that prevents the sale of nonprofit and social housing. And that's where it started. We brought that forward to the government at the time. We brought it forward to the opposition parties. And so this idea around Bill 12 really came from the community and the crisis of the sale of Lions Place. So I'm pleased and supportive of the bill. I appreciate and support the recommendations that the Right to Housing Coalition has made. And I would have one amendment that I would really want to focus on that I would like the government to consider. And that is the amendment to have the responsibility for the decision and the authority around the sale of nonprofit housing be vested in the minister and not the bureaucratic entity. Now, we've heard from the bureaucratic side of things of the sort of the minutia of all around that. I get that, but I think the general public needs to know, and I'm more concerned about future governments, not so much this government, that there is direct political responsibility for decisions that are being made. That when it's
Thank you so much, Tom. Are there any questions? Minister Smith?
So I want to thank you, Tom. You've been a huge advocate for years and years and years, and you've done so much work, not only with seniors, but with our youth. I want to thank you for sharing your story. I'm a, emotional person, so you got me. And, seeing all those seniors and seeing the decimation of community, really, like that was a community. Those seniors had to, move and leave each other. And we've seen that, and we want to ensure that that doesn't happen ever again with our public housing. So this bill is meant to protect our housing that we have and ensure in future governments that that doesn't happen.
Thank you,
So
Minister Smith. Thank you. Tom?
Yes, no, I appreciate that, and I appreciate your description that it was a community, and it feels like that community is getting smaller and smaller at Lions Place, and that's hard. And yeah, I guess just quickly to say around the ministerial responsibility is that if there's perception of wiggle room in future governments that, oh, well, it's Manitoba Housing that made the decision, it isn't us, that doesn't help the community hold future governments accountable. And I would, ask that the government look at making that amendment. It's not costing you any money. And I would also say that it's consistent with the Quebec legislation. If the Quebec legislation is saying the minister needs to have that direct authority, we think the Minister of Housing should have that responsibility as well. So our feeling is that is important for future governments as we in the community are trying to address these kind of things, and that it needs to be political and not deflected to some kind of bureaucratic entity that, while legally people might understand the I's that are dotted and T's are crossed, general public doesn't understand it. And it's easy for a government to say, oh, well, that was Manitoba Housing Renewal Corporation's decision, it wasn't ours, when we know it was, right? So I would urge the government to make that amendment. I think it's small, but it's really important.
Thank you. Questions? Mr. Bariza?
Thank you, Mr. Sims, for your presentation and the information that you brought here tonight. We will hopefully be proposing some amendments that will hopefully encourage more investment into this type of housing. Thank you.
Tom?
Sort of unrelated, but when I sit in the room there, I knew I had to say it. My grandfather and father were originally from Portage, so I don't know how long you've lived there, but 62 years. So he was the inspector there, my grandfather, for many years. And I once saw in the paper they were really proud that he was able to help get one of the schools indoor plumbing and moving away from the outhouses. So that's one of our claims to fame in our family.
Thank you. Any further questions? Thank you. Oh, Mr. Bariza?
Thank you, Mr. Sims. I don't believe I was around at that time.
Thank you, Tom.
Thank you.
I will now recall Gerald Brown. Oh, sorry.
We'll do Gerald Brown at the
He's
end.
done. That was the last one.
Oh, I know what the next one.
Oh, sorry. My apologies. We will move on to the next bill. Bill number.
But before that, we have another written submission from Kevin Rubin on Bill 8. I just need you to say that again.
We've had another written submission from Kevin Rebeck on Bill 8. Does the committee agree to have these documents appear in the Hansard transcript of this meeting?
Agreed.
Agreed, and so ordered. Thank you. Now we go on to Bill 23, and I would like to call upon David Grant. David, can you please proceed with your presentation?
Okay, thank you. Bill 23, based on the prior presentations, seems like a great bill here. We've needed this bill for a long time. Unlike one of the other people who found a problem with a paragraph, I was just so shocked to see it there and so glad that it's going to be helping to encourage people to speak publicly, that I didn't nitpick and look for a problem with it. I just love it the way it is, and it's so much of an improvement over what we have. I'm hoping that it'll encourage more people to do what's sometimes is called whistleblowing, although the public speaking doesn't have to be that. Too many good folks in Manitoba know of malfeasance and want to report it, but they also know they can be victim to prosecution and other vindictive stuff. I've suffered some of that. Ms. Hancock, that spoke before, has experienced that to a much greater extent. But they still want to do the right thing. Until the protections offered in this bill become law in Manitoba, and until the good folks who want to speak out in public know that they are protected, much is wrong with our corporations and institutions will not be fixed. So I have great hopes for it. I was elected to serve on a very important bill, on a very important board. Well, there I discovered much that was wrong. I was able to use normal board processes and motions to correct some of these. In one other case, 10 years ago, I spoke here to Bill 21. I followed the organization's rules for board members speaking in public. we were restricted to only speak in favor of actions of that board. So it was an action of the board 2 years before, and I spoke here in favor of that action of the board. The person who didn't like me speaking then decided that no member of that board could ever speak in public, which is pretty different. Because what happened is the board had made a rule that the organization could make charitable donations to registered charities. Bill 21, 10 years ago, said the organization could make donations. I saw a big difference there, registered charity or just donations to the next door neighbor. And that's what I spoke to, is having Bill 21 incorporate what the board had already passed. Anyway, that was seen as a huge violation of trust, and so they hounded me for a while, and I ended up having to run away. Anyway, the Bill 23, if it had been in place, would have made it simpler for justice and public interest to prevail. Ironically, in the act that governed that organization, Section 56 says that no action shall proceed against somebody acting in the public interest. So they ignored their own act to harass me and chase me out of the organization. So that's something else that I'm not sure how you deal with that in Bill 23. If some organization has such crazy leadership, draconian leadership, that they're going to ignore their own rules, are they going to ignore Bill 23? So just offer that as a cautionary tale that even where there's a protection built into an act, which is good, bad people may still harass good people when they're doing the good thing. So I can leave that to you. And thank you very much, so much for bringing this bill forward. And I look forward to it becoming law.
Thank you, David. Questions? Minister Wiebe.
Thank you very much, Mr. Grant, once again for your presentation. And nobody knows public advocacy like you. You're here for all the committees, and we appreciate that, and protecting your voice in all ways that we can, I think, is important. So thanks again for your presentation.
David?
And in response, I would point out that there are a lot of cases where people needed this, and once it's well known, and again, maybe that's something that one of your people can look at, whether the things that happened to Ms. Hancock could happen after this bill is law. Will people still get away with doing nasty things to good people? I would hope not. And if there's a way of rewording some small part of Bill 23 to make sure no nasty people do bad things after this. So thank you, and thank you so much for bringing it forward.
Thank you, David. Mr. Balkin?
Mr. Grant, thanks very much. I know you've appeared at any committee that I've been at, and certainly bring good perspectives forward. Appreciate you attending committee all the time and having your voice heard. So thank you.
Mr. Grant?
Yeah. It's not just a hobby in retirement. It's I've been involved in provincial politics for 60 years now. In the old days, it was just helping get the Premier of Ontario elected and stuff, but it's been a lifelong hobby of participating and trying to make things better, because you guys are how Manitoba is going to get better, both sides, and anything I can offer to help is definitely worth my time. And thank you very much for the time here.
Thank you. Any further questions? Thank you, Mr. Grant. I would like to now call Ms. Heather Fast. Oh, can I stand? Oh, no, it's okay, sorry. Ms. Fast, please go ahead with your presentation.
Thank you. Good evening, everyone. My name's Heather Fast, and I'm the Policy Advocacy Director at the Manitoba Eco Network. The Manitoba Eco Network is a nonprofit registered charity which seeks to strengthen Manitoba's environmental community with the goal of protecting our environment for the benefit of current and future generations. I'm a lawyer, and a legal academic who spent a long time working with the grassroots community to find ways to improve access to justice in Manitoba. So I'm extremely pleased to be here today to support the passage of Bill 23, the Public Interest Expression Defense Act. Bill 23 will create a new legal pathway to protect citizens speaking up about matters of public interest and discourage the use of litigation as a means of limiting discussion and debate. This type of frivolous lawsuit is also often referred to as a strategic lawsuit against public participation, or a SLAP suit. Anti-SLAP legislation like Bill 23 is an important mechanism for improving procedural justice, ensuring those advocating for public interest do not feel intimidated or afraid to speak up. I've been seeking the adoption of anti-SLAP legislation in Manitoba, modeled after the ULCC and Ontario's Act, for many years, both through my work at the Manitoba Eco Network and my academic studies as a PhD candidate, which have focused on identifying legal mechanisms that can be adopted at the provincial level to facilitate access to justice for Manitobans. Unsurprisingly, anti-SLAP legislation is often recommended as a means of protecting citizens from frivolous lawsuits. Community members have spoken with the Eco Network about their fear of legal repercussions for speaking up about public interests. For example, we've heard from citizens who've received cease and desist letters for making a Facebook post about their environmental concerns. Many citizens will discontinue their advocacy activities when faced with the legal threat, as the potential legal and financial burden is extremely overwhelming. The adoption of anti-SLAP legislation like Bill 23 will help strengthen the ability of Manitobans to advocate on behalf of themselves and their communities without facing severe legal and financial consequences. Anti-SLAP laws help protect vulnerable citizens, such as survivors of gender-based violence, when they disclose or report the violence they have experienced. Anti-SLAP laws also protect those who study, report, and publish about matters of public interest from being intimidated or silenced by costly, time-consuming lawsuits. The Manitoba Eco Network has had a number of great discussions over the last few years with the Department of Environment and Climate Change about our policy and law reform recommendations and the need for anti-SLAP legislation such as Bill 23. We appreciate the time that's been spent listening to us, both by Minister Schmidt and Minister Moyes. Bill 23 has also given the Eco Network the opportunity to build a new connection with Minister Wiebe and his staff at the Department of Justice and discuss our thoughts on the bill. It's nice to feel heard by the Manitoba government and see action being taken to protect public interest advocates. However, there is one big problem with Bill 23 that I hope can be fixed today. Section 4.2 of Bill 23 could result in situations where, when a legal proceeding involves an injunction, the filing of a dismissal motion under Section 3 of the Act will not pause the proceeding, even if the injunction ends up being meritless. We think this exception weakens the protections offered by the bill. There should be an opportunity for the proceeding to be paused, even when injunctions are involved. As a result, we recommend removing Section 4.2 from the bill. Our engagement with Minister Wiebe and his team seemed to demonstrate a clear interest from the Department of Justice in improving protections for those speaking up about public interests. Next week, when I deliver the lecture on public advocacy to my law students that I rescheduled to be with you here today, and we watch this recording in class, I hope I'll be showing them an example of democracy in action, of elected officials actively listening and changing proposed legislation to better protect Manitobans. We want to see a version of Bill 23 that aligns with the approach used in the ULCC and Ontario Acts, meaning no Section 4.2, to ensure there are no gaps in the protection of individuals and organizations speaking up about matters of public interest. Although the version of Bill 23 that was introduced is not perfect, if I was marking it in my class, I'd give it maybe C+ or a B. It's my hope that we will see the removal of Section 4.2 of the bill today, so I can assign the Public Interest Expression Defense Act the grade Manitobans deserve, which is a big fat A+. Thanks for your time and consideration of my remarks.
Thank you so much. Minister Wiebe?
Yeah, thanks so much, Ms. Fast, for your presentation. Looking to get that A+ tonight, but I appreciate it. You know, your support really means a lot because not only are you representing the Manitoba Eco Network, who lives and breathes this reality every day and really tries to navigate these issues, but your academic work has really lent a lot of credibility to this issue as well. We appreciated the meeting and the opportunity to talk through some of the your concerns around Section 4.2, and yeah, we're looking forward to working with you. And thank you again for your presentation, and thank you for the students who are following along and going to watch this later. We hope to see them in committee following your lead and participating in democracy.
Thank you, Minister Wiebe. Ms. Fast?
Thanks. I hope to be back, and hopefully in the future, I will be Dr. Fast instead of Miss Fast, and you can hear about my study results.
Thank you. Anything else? Mr. Balkin?
Well, thank you for your presentation and again, doing the advocacy. I also look forward to seeing the students here in the future because that's what this committees are about, is having that. And it was good to hear finally a passing grade for this government. So, thank you.
Ms. Fast?
Thank you.
Ms. Fast? Yeah.
Thank you. And I appreciate your comments you've made today about the importance of hearing from the public. I very much agree.
Thank you. Any further questions? Ms. Cable, or Minister Cable, my apologies.
Thank you for coming here today, and thank you for being such a phenomenal example to your students. I think that it's so important that we have instructors, professors, folks in positions like yours doing the good work of showing students exactly what this looks like in action. So thank you so much for doing that.
Ms. Fast?
Thanks, and I'll do my best to prepare them for when they come speak to you.
Wonderful. Thank you. I would now like to call upon James Bedham. My apologies if I mispronounced your name. Perfect. James, please proceed with your presentation.
Thank you very much to the committee. Thank you very much to the chairperson. I'm very happy to be presenting here today in support of Bill 23, the Public Interest Expression and Defense Act. I also am going to echo, and I will get into that momentarily, echo some of the comments of the previous presenters that I believe that subsection 2 of section 4 should be removed from the bill. But overall, this is a good bill. I do want to address an opening matter, which been lucky enough to present many times to this standing committee. This is a somewhat unique process in Manitoba. I think only one other province in Canada has the process where anyone in the public can come in, and I think we've heard some great comments today, so I'll make a suggestion, which is, I believe the legislative rules provide 2 days minimum notice for getting a standing committee together. I would suggest upping that to a week so the members of the public can have more time to prepare better submissions and better participate in this process. So just as an opening matter, I want to put that on the record once again, and I hope this might be the last time I have to put it on the record because I see changes as a result of that. Now, once again, this is a good bill. It serves to create a legal tool to reduce the risk that legal action will limit the expression that relates to matters of public interest. I'm speaking today as a private citizen, but I will state I'm called to the bar in Manitoba, and prior to a recent career shift about a year ago, I spent 10+ years working as a lawyer, primarily in litigation. Couple of adages that I found myself constantly telling clients over my decade long of practice was, there's no justice in the justice system. And the sad reality of that is sometimes it's a reality that we need changes in the laws, but more often than not, it's the reality of the inequity in the justice system. This bill isn't going to solve massive economic issues, but the reality is the justice system is hugely inaccessible for people. 10, 25, 100,000 goes very quickly. It's just the reality of it, and it makes it inaccessible. I remember advice that I got as I was about to go to my articles from a lawyer was, realize how expensive we are. Even most lawyers can't afford to hire lawyers. So the reality of our justice system is that very often it's for large organizations and very wealthy people, and that's something that this bill provides a small tool that will help improve that. Another adage I often ended up telling people is, even if you ultimately win the suit, just by being sued, you lose in many respects. Once again, it's a cost issue. right? Because the reality is, once you're served with a claim, you have to respond. If you don't respond, default judgment will likely be rewarded against you. The other party's going to get what they want. And even if you do respond and you fight the suit, the reality is that typically costs are awarded on what's known as a lawyers call a tariff basis, which means in accordance with the cost tariffs laid out in the King's Bench rules. And you can't say for sure, it depends how many hours the lawyer will take, but I would suggest that typically that's about half to 1/3 of the actual cost that people incur. And this is why I think in some ways this bill provides some good provisions, specifically Section 6, which provides costs on a full indemnity basis, which means 100% basis. It also allows for the discretion of judges to adjust that award as they see fit. And I want to highlight the discretion of judges because I think that's very important. I want to make it clear that, I want to get ahead of any the sky is falling arguments that might appear, right? Judges are highly competent in Manitoba. They are good at assessing claims, determining the merits of claims. That's what they do. So I think we need to realize that. And I think realize that, entrust our judges to have that discretion. And this bill simply creates the option of moving forward with a motion to dismiss a proceeding where the judge, on balance, it's outlined in section 3, I believe, where they sort of outline the balancing weight that the judge is going to take to look on balance. The purpose of this proceeding, is it intended to suppress public expression? Now, I will say that subsection 4.2 should be removed. And I think in addressing that, I want to highlight how injunctions typically proceed, because this doesn't mean we will never see any injunctions. This doesn't mean we won't see people having legal protections. There is simply an additional tool, an additional motion that people can avail themselves of if they're going to move forward. But Rule 40 of the Court of King's Bench rules stipulates how an injunction may proceed. And although it doesn't always happen, I will suggest more often than not, injunctions proceed on a without notice basis. That's more common than not. So what that means is that the other side isn't there. It's an ex parte proceeding, so the other side doesn't get to make their arguments. And now, although lawyers, we have an obligation to be truthful and honest to the court, we also have an obligation to advance our client's interest. So you can probably understand in an adversarial system when one side presents arguments, the other side doesn't. It makes a certainly creates some procedural inequity. Then a party typically, once they've got that injunction, now they need to respond. They need to deal with the injunction, how it's going to be dealt with. The main action or application, as the case may be, that originates the proceeding is honestly very often nominal. It wouldn't make it into King's Bench in terms of quantum of damages. They're usually trivial suits in nuisance or trespass or maybe debt new. There may be issues of publication. I can't comment on specifics. Each case is unique to its own. But the reality is that the actual claim itself is generally very nominal. And so that's why it's important that subsection 4.2 be removed, because that injunction itself would be a way to continue to drain a party's resources. It in many ways is nonsensical with the over-intention of the bill. And all it would mean is that the party that then has that injunction would then end up having a motion where the judge would ultimately decide the entire proceeding, whether it has merit or not, and whether the intention of it is to suppress public interest. Ultimately, I just wanted to sort of outline that sort of procedural aspect so that I think members of the legislature understand that. This isn't going to change the world, but it is going to make a meaningful impact. It is going to create an option for people when they're facing what is colloquially known as SLAP lawsuits, strategic legal actions against public participation. And it has broad-reaching impacts, as we've heard tonight. Labor disputes and injunctions on labor disputes, environmental issues, publications, broadcasters, journalists, I think the abuse survivors. There's a broad range of categories. Politicians, right? I mean, you are all lucky enough to benefit from parliamentary privilege when you speak inside the legislature, as are parliamentarians in Ottawa. However, municipal councils don't have that same benefit. They don't have that same protection. You may not have that same protection if you're acting outside of your course of official duties and speaking in the legislature. So this has broad-ranging impacts, and it is a good bill, and it will be made a better bill by removing subsection 4.2, and I hope this government passes it. I hope we see this government pass it unanimously, which is what we saw in BC. It shows that there is a strong unanimous support to a meaningful bill, and it would mean Manitoba would be the 4th jurisdiction, as I understand it, in the country, following BC, Ontario, and Quebec in implementing anti-SLAPP legislation protection for the citizens of Manitoba. Thank you very much. Subject to any comments you may have.
Thank you. Any questions? Minister Wiebe?
Yeah, thanks very much, Mr. Bedom. Very good to see you again. I appreciated the thorough analysis that you brought to the committee tonight. That kind of insider's perspective, I think, is really helpful for us to understand, you know, the impact that this can have in protecting those folks who are vulnerable. And I appreciate your support of this. Again, we met earlier. I'm happy to listen to your concerns around 4.2. Just as a note, you know, this is one of the bills that was delayed by the opposition, and so yeah, I think it's a good question. You know, whether there will be a unanimous support. I hope that there is as well.
Thanks, you, James.
Yeah, I also hope there'll be unanimous support. It's why I actually, you know, I thank you for your meeting and took an attempt. I hope it's okay to speak to the other side, so to speak. I hope we don't see it that way because it's about Manitobans, but about understanding the implications of this bill, and that I also want people to understand that as I said, it isn't Chicken Little. The sky isn't necessarily falling. This isn't gonna, you know, it isn't. It's huge. It's important, but it's not going to change everything. It's not going to change the world. Systematic inequality is still going to exist. We're going to have to make, you know, massive improvements on our economic system, a number of changes, but it is a meaningful tool. So I hope, like you, we can see unanimous consent for this ultimately.
Thank you. Mr. Balkin?
James, thank you very much for your presentation and really putting an expert spin on this for us and bringing that forward. It, you know, it's actually very persuasive, some of your comments that you're making here. So we thank that. And I'll just add to what the minister said, is that yes, we did hold this bill back, and specifically for the reason that we wanted to make sure it was right. We wanted to check with the experts, and we wanted to check with people within the law and citizens that are being affected. So, you know, it's important to make sure we get this right.
Thank you, Mr. Balkin. James?
Definitely, I agree. It's important we hear this right. I think it's important we hear from Manitobans, which, you know, I made the comments about the process, and so I don't know. I put I guess I don't really get to ask the questions, but I'm going to ask one anyway, which is sort of, will we be seeing unanimous support? Has decisions been made now that enough time has been there to reflect and consult with experts?
Thank you. Any further questions? Seeing none, thank you for your time. I would now like to call upon Ms. Louise May. She is on Zoom. So Ms. May, I would ask you to turn on your camera and your microphone, please. Hi there. Ms. May, please proceed with your presentation.
Yes, okay. Thank you very much. I appreciate the opportunity to come at this from my home. I was unable to get downtown, and this offered me an opportunity to share my thoughts on this important bill. I am very supportive of it. I would like to see it go through. I know there are some amendments that have been proposed, and I agree with those amendments. I guess I'd like to bring my own personal perspective to it, having just been through quite an involved process, which made a lot of headlines around. But it was certainly a case where this bill would have prevented myself from being the target of a lawsuit and others as well. So we talk about this concept of people being intimidated to come forward and protect their communities, protect the vulnerable people, protect the history, bring forward important concepts that are not being proactively dealt with by our politicians. And that's, I think, where this needs to start, is that, as we progress as humanity, if we can move forward with more rigorous ethical debate, that we might be able to circumvent some of these things. And really what it comes down to in the situation that I was involved with, which was the protecting and preserving of the St. Norbert Forest, important forest, LeMay Forest, and the important heritage asset of a graveyard of over 3,000 identified children from the orphanage that was on that site from the early 1900s to 1950. Major historical development. And of course, you all know that the province did step in finally and expropriate. In the months that were quite stressful for myself, I will say, and for many others, and the decisions that I had to make as an individual. And I will say that I am also a small business owner. I am 21 years of Aurora Farm in St. Norbert within the city limits. 160 acres, so I manage land, I manage a business, I have a lot of ethical considerations in my business. So I am not coming at this thinking that that other business owners don't go through those same kind of ethical decisions. But when we have landowners, in this case in particular, who are it seems without that sense of community ethics, and that those conversations break down entirely, that what we are left with is literally standing in front of bulldozers, literally holding a fire, a sacred indigenous fire, for months to try to protect and bring awareness. In my own case, in early January, the injunction that was brought on by the owner, the landowner, the injunction, I should say by the landowner's company, so an incorporated company, is able to to create an injunction naming many different people. It named over a dozen people and then numerous Jane and John Does. So that left them open to simply, I wasn't even named on it originally. And some of the people who were named had no idea why they were being named, for instance. So this shotgun approach where a person who has already lost, has already had his proposal turned down at almost every turn, is able to still circumvent all of that and threaten the community by starting to just cut down the trees. And, it's just the bullying techniques. And the evidence that was gathered was all illegally gathered. The developer in question had a video camera in his sunglasses, we found out. Numerous individuals got different kinds of letters from the lawyer that were nonsensical and just simply threatening us. I found myself having to hire a criminal lawyer to defend myself in a civil case. Of the 4 counts that were of the contempt, 3 of them were dropped. And the one charge that was, ultimately I think the most bullying charge was that they wanted me to rescind my private prosecution against the developer and the landowner personally, which was the route I chose to take as an individual to try to stop that, to try to stop the trees from cutting down. And it was a tactic, a maneuver that my lawyer had suggested was something I could do personally. I didn't need to have anyone else with me. I could just go down and file it, and so we did. So this is, and this is coming from for myself, 40 years of activism. I became an activist in my teens, and I have seen many, many different projects and been in different situations. And what we're seeing is this over these years is this inch by inch control that has now led us to this situation where, individuals just are afraid to stand up. And many, I can't speak for them personally, but I will say that I heard from many of the other participants in the LeMay Forest how afraid they were and how they were afraid to go out of their homes because other threats were happening, not just legal. I had someone drive by my house a week before my sentencing hearing yelling, "F you, Louise," a man. And these kind of, like, all these other kinds of bullying techniques that kind of surround the legal thing, very unnerving. So, if we want to, and we're looking at sort of a global sense of loss of democracy. And so to me, the only way that we can protect our democracy is to make sure that individuals who have knowledge, who have experience, who are potentially able to view things in a better ethical way because we don't have the same ties and constraints, that we're able to step up and that we're able to be, present. With the rise of the hatred-based communities that seem to appropriate all of the social and maneuvers that we as progressive activists have pioneered and used over and over, this is another affront against democracy that I don't know. This bill is a tiny, we have to pass it. You have to pass it, but it's a tiny protection where we need a much bigger protection from the government. I'm sure you are all wrestling with these things on a daily basis. So I am just here to say, I hope everyone will be united on making sure that this happens. If we had had this in place, I would have been protected. I would not have had to put myself way on the line to do what I had to do to stop the trees from coming down. So I'll stop there.
Thank you for your remarks, Ms. May. Any questions, Minister Wiebe?
Yeah, thanks, Ms. May. Wow, what a story. Incredible. Thank you for sharing. I'm glad that we could step up as a government. We can protect LeMay Forest, and I'm glad that we're moving on from that. But I guess I'm just reflecting on the fact that this bill, again, has been delayed. The fact that Manitoba hasn't had this legislation because it was never considered or contemplated or passed, voted against, I guess is the way to put it, by the previous government. I guess maybe can you just recount again, just detail how this bill, if it had been in place, the kind of impact it would have had on your situation specifically, and the kinds of pressures that you were feeling, and I guess others in with regards to saving LeMay Forest.
Thank you, Minister Wiebe. Ms. May?
Pardon me. So first of all, I think and someone more knowledgeable than me, James, probably knows this, but that provinces that have enacted anti-SLAPP legislation, I would think that those developers or, people wanting to threaten would be a little bit more careful, a little bit more reticent to get involved in doing that kind of threatening action against the community. I hope. So there's that kind of preventative measure that right there. I myself am not exactly clear, does this come in where a judge, so I watched the judge in my case, like, I mean, I went in front of that judge many times and I watched her not have the tools to throw it out. And I wonder, I mean, again, James maybe could answer this better, or someone else with a more legal mind, that it gives I would hope that this gives the judges a way to preemptively say, yeah, no, we're not going to allow this to go through in the first place. We're not even going to get to a trial. We're not going to enforce, we're not going to allow this injunction to move forward. So, I think the injunction that was out against us, the whole big group, that I ended up being the only one who was tried for that injunction, it had no basis in fact, and it had no evidence, talking about the individual's participation. It was just a big list of names. And like I said, mine wasn't on it. So even with mine not on it, they were still able to circumvent that and use it as a tool to shut me down, or to attempt to shut me down personally. So I'm not representing any group. I'm an individual. I just knew that, that was what I had to do, because I knew that we don't have anti-SLAPP legislation. I knew that that was what they were going to do. They've already proven in several other situations that this is how they operate. So there was no surprise. So to answer your question, I hope it would have curtailed it right from snubbed it out right from the get-go.
Thank you. Any further questions? Mr. Balkin?
Again, thank you very much for your presentation, and bringing your specific case forward here gives us, again, understanding from many different Manitobans. Thank you.
Ms. May?
You're welcome. Thanks for having me.
Thank you so much. I will move to the next speaker, Ms. Diane Bousquet. She is on Zoom. Ms. Bousquet, I would ask you to turn on your camera and your microphone, please. Ms. Bousquet, can you please turn on your camera and your microphone? Ms. Bousquet, please continue with your presentation. Ms. Bousquet, we can't hear you. Can you please ensure that your microphone is on?
Hello?
There we
Hello?
go. Thank you. Please
I
proceed
am
with your
terribly sorry
presentation.
about that.
Ms. Bousquet, please,
Yep, thank you.
please proceed
Hi,
with your
my-
presentation.
Hi, my name is Diane Bousquet, Shining Flowering Thunderbird Woman. I am a Métis woman of Bear Clan, a rights holder and a land defender of the Lemay Forest. I have stood alongside others fighting for the search for Brady landfill, where communities continue to seek justice. truth, and the return of our missing and murdered sisters. I have also walked from Portage La Prairie Residential School, a place my father survived, all the way to Winnipeg, to the homestead of my mother's ancestral homestead. Every step of that walk was an act of ceremony, prayer, and peaceful advocacy, reconnecting generations separated by trauma, calling this province to remember. These acts in search for our sisters, and on my walk from Portage La Prairie and defending the LeMay Forest, I've been assaulted, arrested, and criminalized for standing in peace. These experiences are why I'm here today. I come before you in strong support of Bill 23. I am not a lawyer or a politician. I am a woman with lived experience of being silenced, ignored, and restricted for speaking the truth, for defending land, for protecting the memory of children, and for standing up for what's right. For years, I've spoken in ceremony and in advocacy for lands like the LeMay Forest, a place of a sacred place in St. Norbert that holds deep cultural, spiritual, and significant meaning for our people. In that journey, I've witnessed how systems have often protected those with power and privilege and not those acting in good faith. I have seen justice systems used as a weapon to discourage truth rather than a shield to protect it. Bill 23 brings hope because it recognizes that public participation, truth-telling, and peaceful advocacy are not threats. They are essential to a healthy democracy and to reconciliation in action. While I fully support this bill, I respectfully ask that Section 4 be amended to include the protection of individuals facing injunctions, restrictions, arrests, or legal orders meant to silence peaceful advocacy or expression on matters of public interest. Right now, Section 4 mainly a civil action like defamation, but in reality, many advocates, Indigenous land defenders, whistleblowers, and communities face injunctions, arrests, and court orders that do more than restrict speech. They cut us off from our lands, our ceremonies, and our sacred responsibilities. In my own advocacy, these injunctions did not only limit my right to public participation, they robbed me of my ancestral rights, banning me and others from our ancestral lands and from conducting ceremonies that have been carried out since time immemorial. These were not restrictions based on harms I've caused, but the discomfort of the truth I was bringing forward. Meanwhile, others have used the justice system through threats, injunctions, and procedural tools to silence those working for accountability. That's why I recommend that the section be amended to include the following language. This act applies to any proceedings that arise from the expression of a matter of public interest, included but not limited to acts of defamation or injunctions, arrests, or orders to seek to restrain or penalize public interest expressions or peaceful advocacy by individuals acting in good faith. This amendment would make sure that the law protects all truth tellers, those who write, speak, sing, or pray for change, not just those who do so through formal institutions or media. This summer, I fasted outside the Manitoba Professional Institute of Planners. That fast was not a protest, it was a prayer. For 4 days and 4 nights, I stood in ceremony for truth, healing, and accountability within a system that has forgotten their humanity. It was about reconciliation with the land, with community, and with truth itself. And yet, even peaceful acts like prayer and ceremony can be misunderstood and met with resistance. Bill 23, if strengthened, this amendment could help bridge that gap. It would ensure that those who are acting from conscience, especially Indigenous women, land defenders, and advocates for transparency, are treated as not as adversaries, but as contributors to justice and healing. This bill can demonstrate what reconciliation looks like in law, protecting voices, truth, and honoring the sacred responsibilities we carry for each other and this land. I urge the committee to pass Bill 23, the Public Interest Expression Defense Act, with the consideration of a critical amendment. The protection of public interest expression is not only a legal matter, it's a moral one. And for far too long, fear has silenced the voices that need to be heard most. With this bill, courage can finally be protected, and truth can once again have a rightful place in public life. Thank you for your time today.
Thank you, Ms. Bousquet. Minister Wiebe.
Yeah, thank you, Diane, for your presentation here tonight. You said you weren't a lawyer at the beginning of your presentation, but I thought you laid out a perfect case as to the importance of this this bill. But of course, you did it with heart and personal experience, which I think is probably the most important part of this. I also just wanted to thank you for pointing out your agreement with previous presenters around Section 4(2), and I think that there is a consensus that I'm seeing from presenters and from the public, and of course we're happy to work with you and with the public to make sure this bill is the most effective that it possibly can be. So thank you for your presentation tonight.
Ms. Bousquet.
Thank you.
Any further questions? Mr. Balkin?
Diana, thank you very much again for your presentation. It's important, as I've said to all of the presenters, to hear from Manitobans across our province and all of the different experiences that people have. So I appreciate you taking the time tonight to give us this presentation.
Ms. Bousquet?
Thank you very much for your guys' time tonight.
Thank you very much. I will now go on to Mr. Eric Redder. Sorry if I'm mispronouncing your name. Is it Mr. Reader or Redder? Rader. Oh, sorry. Mr. Rader, please proceed with your presentation tonight.
Thank you. Thanks for giving me an opportunity to speak on Bill 23. My name is Eric Rader. I'm the director of the Wilderness Committee. We just celebrated 45 years of standing up for nature and wilderness across the country just in August, and I've been the director in Manitoba for 20 years. A couple things right off the top. I'm standing here to support Bill 23 anti-SLAPP legislation. I think we were looking at, BC brought this in 2019. So it's an important piece to have in place. The other thing before I forget is that Section 4(2) on injunctions, absolutely, I support the removal of that from this bill, from the stories we've already heard. I'm gonna start by telling you a story from 2010 from BC that would have driven the anti-SLAPP legislation. Taseko was a mining company that was going to mine beside Fish Lake. We were engaged with the First Nation whose territory it was as an environmental organization. We're not consultants. We work on a public need basis. And one of the things we did was their application to open up the mine beside Fish Lake. Their Environment Act proposal, what it would be called in Manitoba, stated that over time it was going to contaminate Fish Lake. We published that to our website. And then we got a cease and desist order, and then we got a lawsuit from Taseko Mines because we'd published the words that they had published in their application to the government to open up a mine. So within a few days of that being made public, the public being aware of that, one of the leading anti-SLAPP lawyers in the country walked into our office, Daniel Burnett, and said, "I'm taking this case on pro bono for you." So that was really good, except that we're looking at losing our organization that had been in place for 30 years because this company is scared of the fact that we publish the things they said in public. And the fact that a lawyer stepped forward and helped us was obviously very good, and it indicates that there's public good, there's pieces that we need to work on. What it took for our organization was a complete revamp of what we were allowed to say in public. And it took more than 100 hours of dispositions with this lawyer so that we could clear ourselves through this case. We eventually won the case, which is excellent. But again, it took a lot out of our organization to do this. So then fast forward to 2019, BC has passed their anti-SLAPP legislation. The letter that I've handed out to you is directly as a result of my work in Manitoba. During the pandemic, doing some research on caribou in Nopaming Provincial Park. One of the things that I looked on the Mines Branch website is I found mining claims that are inside the protected area. And I'm like, well, that can't really be. Like, who would make this mistake? This isn't possible. So I planned a trip. I took my kiddo out with me, and we paddled out on May Long weekend, and I documented GPS coordinates, photographs, drone footage, everything I needed to show that this mining claim is explicitly inside a protected area, which is illegal. Came home with the documentation, loaded it all up. This is a big deal. And then within a couple of days, I got this letter from the lawyer. So immediately, we're scared. We're trying to figure out how to protect our provincial parks. So when we talk about the personal and what this means, we've heard from other folks who talk about the risks that they've went through. There isn't anybody who speaks up for caribou. There's nobody who speaks up for our provincial parks. And I would imagine that everybody in this room here has fond memories of going and visiting provincial parks. And we lose pieces of those when we don't care for them. And so in this instance, again, Daniel Burnett, we contacted him. It wasn't pro bono this time. We sent over this. I've given you the news release that showed what we said in public and the letter that we got from the lawyer. Very explicitly in Manitoba, the reason we need this anti-SLAPP legislation is so that people can speak up on the public good. If I had said something wrong and I was getting sued because I had defamed someone, that's an entirely different situation. But we're stating the facts about what is happening for the animals on the land in Manitoba. So those pieces are direct. That was all I was going to present on today, but I really want to touch on something that Louise May talked about, and then Diane just presented on. I was part of the LeMay Forest fight for 120 days this year, and it was a hard thing. I would suggest that in January, I got a very terse message from the lawyers for the developer, for the owner of the LeMay Forest. That put me into again, looking for lawyers to hold this up, say, wait, why am I being told to do all this work for this lawyer? This isn't the way things are supposed to go. What I would suggest is that lawyers are, without anti-SLAPP suit, lawyers are emboldened to lash out at people and to pressure people. And they're emboldened because there is no response. There's nothing that people are going to do. So folks who can afford to hire lawyers get to control the narrative. And that happened for quite a while on LeMay Forest, because LeMay Forest was a 5-year battle that only culminated in a real decision being made by this government in the last 120 days. So what we do for public good here, for standing up for any piece of society, whether it's talking about social housing, which has come up here today, or talking about funding or organizations. MJ talked a little bit about what it was like to be in First Nations, be in Hollow Water, and be trying to confront the chief and council about their decision making. I was followed around Hollow Water on that same campaign by the RCMP every single time I showed up in the community. So there's a place where power imbalance exists, and it's up to you as leaders of this province to figure out how to sway the power imbalance back so that we as a collective can look after ourselves, we can look after nature, we can look after climate. And that's pretty much the extent of my presentation today. Thank you.
Thank you, Mr. Rader. Questions? Minister Weed?
Thanks, Mr. Rader. You know, I got to admit, I appreciated what you shared here today, and it makes my blood boil to hear the ordeal that you've been put through. And you know, we've heard from numerous others, high-profile situations, who've experienced the same kind of thing. So I know that you're in good company there. But I'm just wanted to express, the frustration along with you. You know what you had to go through. And I'm really happy that we can bring this legislation forward, and I do hope that it gets all party support. We just get this done. I can't believe we delayed it this long. Let's get it done, and let's protect the good work that you're doing. Thanks again.
Thank you. Mr. Rader?
Thank you.
Mr. Balkin?
Thank you, Eric, for your presentation and really bringing what you had as firsthand experience forward on this. So again, I know the minister said it several times that this was held back, but for good reason. We want to make sure that the legislation is proper and meets what everybody is looking for. So thank you for being here, and thank you for your presentation.
Mr. Rader?
Yeah, thank you. I would say that the more indication that people see in public of people working across the aisle, the easier it will be to turn down rhetoric, the show of support behind things like anti-SLAPP, which really goes to empower citizens to be part of their society. Things like, again, climate legislation, having people from both sides of the elected House, from all three parties in the elected House, standing together and passing messages on to the public instead of looking for ways that they can be political. Some of the things are much more important than who's going to win the next election, because we're running out of time for caring for society, nature, and climate. And you guys are in the seat right now, and we're going to be looking back and remembering that you guys had that opportunity to collectively get together. This is the time for you to do this. Thank you.
Thank you. Any further questions? No. Thank you for your time, Mr. Rader. We will now move on to Bill number 30. And I would like to call upon David Grant. Mr. Grant, please proceed with your presentation.
Thank you. In contrast to the other three bills that I spoke to, which I was pretty completely in favor of, and I didn't discover problems with them, but others did. In the case of Bill 30, it's a bit different, and maybe I'm not interpreting it correctly, but I've been doing this politician and voting and elections thing for a very long time, since the 50s, and voting was once limited by law and procedure to citizens. Bill 30 seems to ignore that principle. I would like wording added to Bill 30 that would bring this back in. I understand that Alberta tried to, they're going even farther, putting citizenship status on driver's licenses, which is a radical step. And to do that, they were unable to get Ottawa to provide them with who's a citizen and who isn't. So if Ottawa doesn't know or won't say, it might be difficult, but it would be nice if Elections Manitoba had that as one of their guiding principles, that when people are being added, that they be citizens, and Bill 30 seems to be missing that. It allows the CEO of Elections Manitoba to use any trusted means to add names, and so that's a bit troubling, but I'm not sure there's a good solution if Ottawa can't help us. Another principle concern I had is that most of the political action groups in Manitoba, the EDAs, are in non-held ridings, that if the Liberals have one, almost all of theirs are non-held. And for an EDA, this is the Electoral District Association, the local volunteers, in a non-held riding, they take in nearly $0 a year, and they spend nearly zero. They might buy donuts, they might not. And any attempt to require a lot of money to be spent on audits could financially ruin them. Maybe I'm misinterpreting it. Maybe that's only in election years, but it's a concern. I remember decades ago when I was in charge of the South Winnipeg, or secretary of the South Winnipeg Boy Scouts, and we wanted an audit performed. And it turned out at that point, anybody in Manitoba could perform an audit. You didn't have to be a CA or anything like that. But anyway, just the idea of laws that require an action to be taken are good, where the law says, and you must spend this much on that service. If the organization is impecunious, has no money, and wants to have their books certified by a third party, looked over, and there's almost nothing to it, if that can be done for $50, you know, for somebody to peruse the 3 entries and sign off, we shouldn't be required to spend thousands. Just a comment, and if I've got it wrong, I'm sorry, but if the bill does actually require non-held tiny EDAs to spend a substantial amount of money, I think it's a bad idea. The other is advance voting. It does spell out advance voting, that the time period it should cover. I've sat at a lot of advance voting and regular election day voting as a volunteer scrutineer and as an employee of Elections Canada. And a lot of the time it's pretty boring. You bring a newspaper because nobody comes in. And it strikes me that if you go for a lot of 12-hour advance days, that's great for marketing. You know, tell the public from 8 to 8, come on in, and all these days. And that's about as generous as we can be for the public. But it means that almost all that time by all those employees is wasted. And I'm not sure how we deal with that, but if we know that the busy time is from 4 to 6:30, being open from 4 to 8 rather than 12 hours for a bunch of the advanced days might be a better use of resources. And just want to make that comment as somebody who's been sat bored for way too many hours with no customers. And obviously something like Bill 30 is a good place to put that in because it does make reference to advance voting. And advance voting that turns up 5 votes an hour is not something to be proud of. If we want to pretend that those 5 votes would never have voted, you know, sure, but I think there's time to rationalize this. I know we aren't private industry and we shouldn't pretend to be, but there is reason to rationalize it. I guess there are a couple other things involved here. That I understand that the Bill 30 expects, or the law expects one of the political parties to investigate if there are complaints. And that's interesting because I've seen the Law Society is allowed to do their own investigations of their own problems. Professional engineers do the same, and it goes horribly wrong because what somebody who wants to let the bad guy off the hook calls an investigation is not something you and I would agree is an investigation, which then brings up it'd be a good idea if for legislative purposes, for the purposes of Bill 30, for the purposes of other acts, where you guys call for an investigation. I think the widespread dismissal of things that should be investigated by doing fake investigations, it would be good if we, and again, I may be working with Minister Weeb's person there on this, but if we spelled out what we mean by investigation, it doesn't mean you call up the criminal and say, that wasn't such a bad thing, was it? And then you toss the complaint. I think there should be standards for what we call an investigation of a professional complaint or a complaint on an elections issue. So there are certain things, like I've done professional investigations. You got a problem in a company, and we gather information. We gather it as widely as we can, and the report describes what we did. As far as the investigation, looking up old records and talking to people and so on. And I think any investigation should be required to provide a report, and the report should describe the procedures used, the philosophy and what we did to investigate. Because right now, as again, Bill 30 calls for parties to investigate complaints, and I have dire feelings that this is going to end up just as bad as if one of us complains to the Law Society and they decide, oh, that guy's pretty important here, we're tossing that one. I'm afraid, especially if it's a party investigating a complaint, that they're going to be doing not the kind of investigation we would be happy with. So again, Bill 30 may not be the place for it, but Bill 30 is another area where the government of Manitoba requires an investigation. There's a complaint, we want to investigate it. A lot of the stuff people were talking about under Bill 23 would qualify also as complaints that should be dealt with. And if the organization doing the investigating is allowed discretion, and the person that is being investigated is important, and it'd be better to have them an unstained reputation, we can expect a non-investigation. So it's a little off topic, but it is in there. So for one thing, if there's going to be an investigation, asking the group that may have benefited from the problem is maybe asking too much. You know, it's certainly, it's been suggested before. I think that's why we have police have special organizations to investigate stuff that may be done badly by police, rather than having the detective who has lunch with the accused person investigate. So that's a different matter, but the problem is one in common. So as I say, I think we need a standard set, and I can work with your person, Mr. Weeb, on that, on what an investigation should incorporate. And the report should describe all the things that were done in the investigation, and we should require that. So anyway, but it is common to many pieces of legislation in Manitoba where we require this to be investigated. And I have many pieces of evidence where a bunch of stuff was sent in with the complaint. You find out later that it was dismissed, and you say, why? Well, there was no evidence. What happened to that pack of stuff I sent you? And
thank you, Mr. Grant.
Sorry, yeah.
You can finish your remarks during the 5-minute question period. Are there any questions? Minister Weeb?
Yeah, thank you, Mr. Grant, once again for the presentation. I think you have the same goal as our government and of Elections Manitoba, and that is to enhance and protect our democratic institutions. So thanks for your perspective on it.
Thank you, Mr. Grant.
The topic of elections, although I think those are still valid points that we try to set up the advance to make maximum use of people. And the citizenship thing is not easily solved, but I'd like it to be worked on. And the finance thing for the EDAs. And as I say, the other part, I was pretty much done. I guess the idea that if you dissent from the view that elections are perfect, in some circles, that's a crime. I think federally they've done that. If you say things aren't good in the election process, you can be charged with a serious offense. And I would think that creating a lie about elections should be prosecuted. But saying, hey, what about this? Or what if somebody does that? If you're raising questions, that should never be a crime in Manitoba. And so that was, thank you very much for your support, Mr. Weeb. And that was my other comment.
Thank you, Mr. Grant. Mr. Balkin?
Well, thank you, Mr. Grant. Again, always coming up with ideas and thoughts on the various bills, and it is appreciated, and thanks for your advocacy.
Mr. Grant?
Thank you.
Okay. Any further questions? Minister Cable?
Thank you again for your presentation and being so engaged. You mentioned protecting our democracy and strengthening what we have here. Do you have any sort of last words about what we can do to continue to strengthen our democracy here in Manitoba?
Mr. Grant?
I'm sorry, yes.
okay.
There are some, I won't call them existential, but there are some threats to what we expected of democracy all our lives that nobody is talking about. And one of them is citizenship versus non. So that's, again, hard to settle. If Ottawa isn't keeping track of who's a citizen, how are we to do it? The other is the effect of media, that we find that media in some cases can see, because they're in the room, when really strange stuff is happening at City Hall, and people are presenting evidence, this is a problem, and City Hall ignores it. And so the public never know that unless they happen to be watching the YouTube. So that's another area of concern. The whole idea of the federal government paying the salaries of almost everybody that reports on the federal government is problematic. I think in other countries it would never be accepted, but we have. So that's, as far as the protection of democracy, I think the idea that we have a solid form of you people responding to us, speaking to us, and we get to speak to you, and you're very responsive and do the right thing. That's wonderful, and I think the idea that, and I guess the security of the ballot is something that's been an issue, more so in the U.S., where there are examples of boxes being brought in after the candidate loses. Well, let's bring in 4 more boxes and now he wins. That sort of thing we don't see here, and we don't want it. But it does speak to the integrity of the ballots, and that's one thing. Paper ballots take forever to, well, they take an hour to count, but machines are so easily tricked that I would hope that we stay with a piece of paper. And thank you very much for your question, Ms. Gable.
Thank you so much for your time. I will now go back to our list. So for Bill 8, Mr. Victor Vrisnik.
Call him again.
Mr. Victor Vrisnik.
Mr. Vrisnik will be dropped.
Mr. Vrisnik will be dropped from the list. We now move to Bill 12, Gerald Brown. Gerald Brown. And Mr. Brown will be dropped from the list. That concludes the list of presenters I have before me. In what order does the committee wish to proceed with clause-by-clause consideration of these bills?
Mr. Weeb.
Minister Weeb, how would you like to proceed?
Thank you, Chair. I would suggest that we proceed through the bills in numerical order.
Okay, we will now proceed with clause-by-clause of Bill number 8.
Hold on. We need to do a committee substitution.
Sorry, we need to do a committee substitution.
Or hold on.
Mr. Uwasco?
Yeah, so we're going to be doing a substitution. Myself for Mr. Breeze on the committee. Right now, we're going to do Bill 8 first. Well, I understand, but I just figured since we're at the start of everything, so. But go ahead. No, I'm happy to.
Before, no, please don't turn.
It was previously suggested that we go through the bills in numerical order. However, there was a suggestion to go through the bills in numerical order, but start with Bill 40 and then move to Bill 8. Is it the will of the committee? Agreed?
Agreed.
Agreed. Thank you. I would like to inform the committee that under Rule 84-2, the following membership substitution has been made for this committee, effective immediately. Minister Schmidt for Minister Cable. Thank you. Does the minister responsible for Bill 40 have an opening statement?
I do.
Minister Schmidt?
Thank you, Honorable Chairperson. Thank you to the members of the committee. Thank you to all of the presenters here tonight, both those that were in person and for the written submissions. Thank you very much for your time, your thoughtful consideration of Bill 40. As Minister of Education and Early Childhood Learning, I am very proud of this bill, and this bill does many important things. All of which are intended to modernize the Education Administration Act and the Public Schools Act and to bring them into 2025 so that our observances in our public schools reflect and respect what Manitoba is and who we are as Manitobans. So one thing Bill 40 does is long overdue, and that's to remove the part of the act that mandated religious exercises in the classroom. The courts here in Manitoba decided that that was an unconstitutional practice back in 1992, but the rule nevertheless remains on the books, so we are now taking it out. We could perhaps call that a bit of housekeeping. Another important thing that Bill 40 does affirms and legislates patriotic observances, including O Canada, Remembrance Day, and citizenship exercises. These previously existed in regulation, and a part of what Bill 40 does is entrench those important patriotic observances into legislation. Bill 40 will make it law that every day in every public school, O Canada will be played and respected. Because, perhaps now more than ever, our youth need to be united and to take pride in their country and everything that it stands for. Bill 40 also makes it law that not only will every school observe Remembrance Day in order to honor Canada's veterans, but we're also making it more flexible so that schools can honor this sacred day in a good way. Previous regulations provided that Remembrance Day must be observed on the last day of school before November 11th. Schools and veterans and legions alike have been asking for this change to the regulation to allow for greater flexibility on which day Remembrance Day is observed in schools, to allow for greater participation, for the coordination of veterans and legions to, again, allow greater participation and more meaningful participation across many schools. They've asked, our government has listened, and now we will enshrine that into law. As I've said, part of the intention of Bill 40 is to modernize the acts and bring them in line with what is common practice and common and acceptable practice in our schools today. So in that theme of enshrining into law what is already in practice in classrooms across the province, and thank goodness across the country, is Bill 40's requirement that school boards establish policies regarding land and treaty acknowledgements, like so many schools and school divisions have already done. These schools are, many schools and school divisions are already doing land and treaty acknowledgements in practice. In fact, and I think most of the committee members would probably agree, in every school I have had the great fortune of visiting, land and treaty acknowledgements are a regular practice. And in fact, I would suggest that there is maybe no space where we see the work of the Truth and Reconciliation Commission and the late Justice Murray Sinclair more clearly and abundantly than in our public school system. That work goes well beyond land and treaty acknowledgements. We see in our schools today land-based learning. We see examples of the 7 sacred teachings. We see Indigenous language courses and clubs. So I just want to take a brief moment to thank school leaders, educators, and most importantly, the kids for their leadership and for their important work on reconciliation in the classroom. We are going to make sure that this good work does not slide backwards in a day where we have elected officials who would deny the history of residential schools and the harm, the intergenerational harm that is, continues to rear its ugly head in our society today. We're going to make sure that that good work doesn't slide backwards. We're going to make sure that this is law in Manitoba. And finally, yes, Bill 40 does remove the requirement to sing God Save the King every day. Manitobans know that this fell out of common practice decades ago. Schools have independently made and affirmed those decisions for years, year after year, for a variety of reasons, some of which we can discuss here tonight. But first, let's be crystal clear. Nothing in Bill 40 bans God Save the King. That's just division being sowed by the opposition, who would prefer that Manitobans would continue just fighting each other so that they don't notice the utter corruption and failures plaguing the PC party and the PC leadership. So they would have you believe that this is some conspiracy to ban the song or to discount the monarchy, but nothing could be further from the truth. If a school community or a classroom teacher decides that the singing of God Save the King makes sense for their students, please, by all means, sing away. But I want to bring us back to the work of reconciliation being done in our classrooms across our province and why we do that work, including land and treaty acknowledgements. It's to bring to light the terrible history of colonialism, including the racist policy of residential schools and the impacts that that history has on Indigenous people of this land that we call now Manitoba. Those impacts are felt today. We can see them and hear them all around us if we are listening, and if we are committed to the truth and to reconciling that truth so that Canadians and Manitobans, we can find a better and brighter path forward together. So if we are going to acknowledge the real and ongoing intergenerational harms of colonial policies, including residential schools, where kids were stolen from their families, forced to abandon their culture, their language, their ceremonies, their ways of seeing and knowing the world, they were stolen from their communities, from their nations, and forced to pledge allegiance to a crown that had inflicted harm upon them. If we are going to acknowledge that truth and the real harms that flow from it, then I can absolutely understand that why for some school communities, for some classrooms, they might decide against that as a daily practice in their schools, and that's okay. Bill 40 allows for the freedom to choose, and we expect that those choices are guided always with the best interests of the child at the center of those choices, so that each and every child knows that they matter, that they belong, that they are safe and included and respected in the classroom. That is at the cornerstone of all of my work as minister, of all of our work as the NDP government. I will continue to work closely with all stakeholders and experts in the sector as we communicate to implement these changes. I look forward to the unanimous support of this committee. Thank you very much.
We thank the minister. Does the critic from the official opposition have an opening statement? Mr. Uasco?
Thank you, Madam Chair, and it's interesting that Bill 40 comes forward and then the minister goes off on a little bit of a tangent, but that's okay. That's there's nothing new with you-know-who and his government officials. So when we talk about legislating Canada on a day-to-day basis, we on the Progressive Conservative side have teachers and trustees, and we also have teachers and trustees on the NDP side. And we know as teachers, Canada is strongly suggested to be sung at the start of each day. We are in support of this bill to a certain degree, bringing forward the Remembrance Day and being able to give schools and school divisions the flexibility of the various different days to practice it, because we know that especially in rural communities, there's many officials and legions that have multiple schools. And so this way it gives the opportunity for the flexibility within those communities to hold Remembrance Day ceremonies at the schools and have those various veterans and organizations attend those very important ceremonies, which lead us to evenings like today, where those men and women that have gone before us and continue to fight for our freedoms on an everyday basis allows us to enjoy the democracy that we have today. And Manitoba being one of just a couple provinces in this great country of ours that actually has a committee stage. And so I'd like to thank the presenters who came on to speak to the bills that have been brought forward. We held this bill up to get a chance to have those conversations and collaboration with many of those education partners and stakeholders all across this great province. Parents, guardians, teachers, support staff, bus drivers, senior administration, and of course, school boards and that. And so when we talk about also land and treaty acknowledgements, we know that is already sort of ingrained in many schools and school divisions already. And I know being former education minister in this great province of ours, it was our government that brought forward many of those practices and put them in place into documents that, I'm hoping that the now education minister doesn't try to turn back time and get rid of some of that really good work that has gone forward in this great province of ours. That being said, the minister said herself that this is something that we're giving the freedom for school divisions and schools to come up with their own policies and freedom of choice. And so even though we're going to be supporting this bill, we're going to be supporting this bill with the addition of a couple amendments. And that is to continue that free choice so that it's actually written in the regulations that schools and school divisions can continue on with that choice. It's not fear-mongering, as the minister says. The minister's really good at trying to put forward wedges. And she's done this since she took over in the education file. And she can't seem to handle the fact when she's given a little bit of pushback, respectful pushback, but then we can see the partisanship ramp up in behavior and tone. With that, we are going to be bringing forward a couple amendments. I don't see, or we don't see, and many of the stakeholders and education partners across this province don't see any need to get rid of the regulations, to get rid of the Royal Anthem. We think that it is a good option. Do many schools practice it? No, but during certain times of the year and that, definitely they do, and some schools do, and some schools still want to do it. The minister says that it is their option to be able to still practice that, but you know what? If it is that case, if it is that way, there's no reason to not keep it in there as an amendment to this bill. I mean, for goodness sakes, we saw, the premier, pat himself on the back and touting the king and receiving the medal on the King Charles III Coronation Medal from the Governor General Mary Simon back in November of 2024. And 2024, Premier Canoe awarded 27 Manitobans with the King's Coronation Medal to recognize their contributions to the province, country, and the world. I had the pleasure as leader of the opposition at the time to award 3 medals, and every other sitting MLA had the privilege and honor to acknowledge and give out 2 additional medals. So I don't think that it's really that much of a stretch since the minister decided to go a little partisan. What many people need to know out there is the fact that we in the chamber had put forward some suggestions to sing O Canada at the end of each and every day. And there's probably 85 to 90% of the NDP caucus exits at the end of the day and does not partake in O Canada. There are a few that still participate at the end of the day singing O Canada. So it's interesting that they can't just see it and instead of talking out of both sides of their mouths. So with that, Honourable Chairperson, I'm going to leave it at that and proceed to the clause by clause, and we will be bringing forward the 2 amendments which, again, hopefully unanimously, we pass this bill with the amendments and move it forward to 3rd reading. Thank you, Honourable Chairperson.
We thank the member. During the consideration of a bill, the enacting clause and the title are postponed until all other clauses have been considered in their proper order. Also, if there is agreement from the committee, the chair will call clauses in blocks that conform to pages, with the understanding that we will stop at any particular clause or clauses where members may have comments, questions, or amendments to propose. Is that agreed? Agreed? Shall clauses 1 through 3 pass?
I hear a no.
I hear a no.
Shall clause 1 pass?
Shall clause 1 pass? Shall clause 2 pass? Shall clause 3 pass?
Oh, sorry. Sorry, you have to say clause 1 is accordingly passed.
Clause 1 is accordingly passed. Shall clause 2 pass? Clause 2 is accordingly passed. Shall clause 3 pass? Clause 3 is accordingly passed. Okay. Shall clause 4 pass? Clause 4 is accordingly passed. Shall clauses 5 through 7 pass? Clauses 5 through 7 are accordingly passed. Shall clauses 8 through 10 pass? I hear a no. Shall clause 8 pass? Clause 8 is passed, is accordingly passed. Shall clause 9 pass? Clause 9 is accordingly passed. Shall clause 10 pass? I hear a no.
Thank you.
Thank you. Am I reading this? Mr. Iwasko?
Thank you. So I move that in committee, the proposed amendment to Bill 40, an act respecting O Canada and other observances and land and treaty acknowledgements in schools, open bracket, Education Administration Act and Public Schools Act amended, close bracket, that clause 10 of the bill be amended by adding the following after the proposed section 85. School board may direct singing of Royal Anthem 85.0.1 bracket 1 close bracket. A school board may, by bylaw, direct the singing of the Royal Anthem in bracket God Save the King end bracket in each school at the times and on the school days specified by the board. Singing of Royal Anthem in particular schools. 85.0.1, open bracket 2, close bracket. If no direction has been given, the principal may approve the singing of the royal anthem in the school at the times and on the school days specified by the principal. Consultations, 85.0.1 bracket, open bracket 3, close bracket. Before directing or approving the singing of the royal anthem, consultations must be held with A, the Parent Advisory Council, Parent Council, or School Committee for the relevant schools or school, and B, residents of the school division or school district, or in the case of a particular school, the area served by the school.
The motion is in order. It has been moved that by Mr. Uwasco that clause 10 of the bill be amended by adding the following after the proposed section 85. School board may direct singing of royal anthem. 85. Thank you. Dispensed. Dispensed? That's what I was looking at. Okay.
She said one.
The floor is open for questions. Minister Schmidt?
Confirming that I have 45 seconds?
No, we have to.
Thank you. Okay, so thank you to the member for Lac Du Bonnet for the amendment. However, I will note that this bill was first introduced into the legislature in March of 2025. Between then and now, and I would argue including tonight at committee, we have had no one from the sector, no one from the community ask for this type of provision. So I'm not sure what is motivating this. What I fear is motivating this is a desire to continue to muddy the waters, to continue to sow division on this issue. Again, I regret that the member opposite did not listen to some of my opening comments that highlighted the incredible work of this bill. Instead, he continues to zero in on this notion about God Save the King, which again, we introduced this in legislation, we introduced this piece of legislation for consideration in March of 2025. I can confirm as minister that I've received no correspondence to date asking for the amendments that have been put forward here today, so I can confirm that for the committee. The purpose of Bill 40 is to modernize these acts and to provide further clarity. I would argue that the amendments actually provide very little clarity and in fact are quite confusing and in fact redundant because as I've said in March when the bill was introduced, as I've said here tonight, Manitobans have the freedom to make this choice. If Manitobans choose to sing God Save the King in the privacy of their own home, if the school community and a classroom leader decides that's appropriate for their classroom, they're absolutely free to do so. And so this amendment, I would argue, would be redundant. Thank you very much, Honourable Chairperson.
Thank you, Minister Schmidt. Any further questions? Mr. Uwasco?
I don't have any further questions. I guess it's my amendment that we brought forward, so I didn't hear a question there. But since the minister rammed this through in March and again representing Manitobans and the opposition party, we do have the democratic right to hold back certain bills and do further consultation around the province, and we have done that, and we've spoken to parents and guardians and school divisions, trustees, superintendents, principals, teachers, support staff, custodian staff, school bus drivers, anyone else within this education world, former teachers, professors, university professors, college instructors, and they felt that to bring forward a friendly amendment to bring further clarity was not muddying the waters, as the minister says. Matter of fact, this brings even clearer direction that, and this says, it's highlighted, the word may is there. So it leaves the choice there for schools and school divisions to move forward if they see fit, to be able to sing the royal anthem, God Save the King, and maybe the minister can answer why she wants to, potentially get rid of it. She stated in her opening comments that she doesn't want to get rid of it, that it's there, this is a redundant thing. So this amendment brings it in, brings super clarity to the fact that it is still a choice for school divisions, schools, and administration to make those decisions for their school community. Thank you, Madam Chair.
Minister Cable?
Yes. So you mentioned a number of folks who were really emphatic about this very confusing, unnecessary amendment. And I just wondering where those folks are. They've had the opportunity to, from, did you say April? March. From March until now, to come forward and join you in supporting this amendment, and I'm wondering where they are. We had dozens of committee presenters this evening, none of whom presented this or ideas behind this. So where are those folks, and why didn't you do it while you had the opportunity?
Mr. Iwasco?
So I appreciate the minister bringing forward her question and reading off the same talking points that the minister has. In regards to the presenters tonight, there were, I believe there was one presenter on Bill 40, and he thought that it was a good idea to bring some of these things forward. Not everybody in the public necessarily knows exactly what is happening here at the ledge on an everyday basis. And so that's why we held it back, needed some further discussion to try to make it right and to bring some clarity to bring it forward the choice for school divisions and schools. I have listed off those individuals that I spoke with, the groups of people that I spoke with. Maybe the Minister of Advanced Education had those conversations with professors and former teachers and deans of education and things, and maybe has shared that as well, maybe or maybe not with the Minister of Education. I don't know. I haven't asked her that question. Thanks, person.
Is the committee ready for the question? The question before the committee is as follows. That Clause 10 of the bill be amended by adding the following after the proposed Section 85. School board may direct singing of royal anthem.
Dispense?
Dispensed?
No, dispense?
Shall the amendment pass?
Yes.
I hear a no. The amendment is.
Yes, I hear it. No, we have to do ayes and nays. So we have to do this one.
Okay.
Life is just
Great.
There we go.
All those in favor of the amendment, please say aye.
Aye.
All those opposed, please say nay.
Nay.
In my opinion, the nays have it. The amendment is accordingly defeated.
Okay. And is accordingly defeated. No, it's not amended. Never mind. We're going to move along.
Okay.
We're done 10. We're going to go to 11.
Shall Clause 11 pass?
No.
I hear a no. Shall Clause 10 pass?
Yes, thank you.
Thank you.
Oh, wait. Okay, I see the issue.
I hear a no.
No, there's
Nope.
no no's.
No no's, doesn't
Yes,
matter?
there's yes.
There's an amendment to the amendment
No.
or a new amendment?
It's a new amendment. Mr. Owasco.
Mr. Uwasco.
Thank you, Madam Chairperson, and I move, and I will take the wonderful guidance from our wonderful helpers in the back of the room, and I won't read the whole beginning. So I move that Clause 10 of the bill be amended by adding the following before the proposed section 85.1. A period of reflection. 85.0.2, open bracket 1, close bracket, a school board may, by bylaw, direct that pupils be given time for a period of reflection at the conclusion of the opening exercise of the school day. Consultations, 85.0.2, open bracket 2, close bracket, before directing that a period of reflection be held, the school board must consult with A, the Parent Advisory Council, Parent Council, or School Committee for the schools in the school division or school district, and B, residents of the school division or school district.
So if the amendment is in order, the amendment is.
No.
It has been moved by Mr. Uwasco that Clause 10 of the bill be amended by adding the following before the proposed Section 85.1 dispensed.
It's a question. Dispense?
Dispensed? Okay.
The amendment.
The amendment is in order. The floor is open for questions. Minister Schmidt.
Thank you very much, Honorable Chairperson. Thank you to the member for Lac du Bonny for this amendment. I'm curious if and why, in his time, as the committee knows, prior to his role as critic, the member for Lac du Bonny was the Minister of Education. So I'm curious about where all these good ideas for these amendments to the Public Schools Act were at the time when he was minister. But regardless, I will say that in principle, to give my friend some credit, I think in principle this is a great idea. I think legislating it is absolutely redundant because I think this is something that is happening in practice in our schools all over the place. So I wonder if he's been to visit any schools lately that are doing these type of practices already. For example, I can share with the committee that recently I paid a visit to École Sun Valley School, which is a K-5 school, I believe. And I walked into the gym at the beginning of the day, and there was a bunch of children sitting at tables, and the lights were down low, and it was completely silent. And I thought, is this a mass detention? I didn't know what was going on. And so I asked the educator that was touring me around the school, what's going on here? There was probably 100 kids in the gym, lights down, eating quietly. And she said, this is our reflection snack. It's something that we've been doing. So it's, by the way, part of our government's, the NDP government's $30 million annual investment to feed every single school, every single child in every single school across this province. Any kid that needs it has access now to healthy, high quality, free, barrier-free food in schools. So as part of delivering that NDP nutrition program, this school has incorporated into their breakfast program reflective snack for their breakfast program. And according to this educator, the students not only really enjoyed it, but she talked about how much it benefited their daily learning and how it really set a great tone for the day. And so in principle, again, I think this is really great. I also would share with the committee a practice that is in River East Transcona School Division of interactive start. I don't know if anyone's heard of this type of practice, but it's common practice in the sort of the middle years and specifically in the middle years in River East Transcona, where the day starts with interactive start. And that's where there's a variety of different types of activities that children can choose to participate in as a way to start their day. And some of those, sometimes it's a chess club, sometimes it's a yoga practice or a meditation practice or a reflection. So in principle, I think this is a lovely idea. I do have some concerns about the fact that it would have to mandate it at the conclusion of the opening exercises. I think that students and teachers need the flexibility to be able to have these kind of excellent practices throughout their day. And again, I just want to, again, thank and highlight and the great work that educators are doing in classrooms every day to bring in great ideas like this. They don't need the government to mandate it. This is the work that educators and school leaders are doing every day, and we support that work, and we encourage them to continue that work, and we believe that this amendment would be redundant. So again, I'll ask the member opposite where this idea was when he was minister.
Mr. Iwasco?
Thank you, Madam Chairperson, for the opportunity to answer the minister, and it gives me great pleasure, and it's welcoming to hear that the minister is probably going to support this amendment, considering it's a great idea. Again, being not only the education critic and former minister, visited many schools, and just this year alone, probably over 10 schools, not only in my constituency, but in others as well. And the period of reflection is not consistent. And, as far as the minister talking about mandating things, well, that's what Bill 40 is doing, mandating O Canada, at the start. And basically what this amendment brings forward is that a period of reflection would be at the conclusion of opening exercises of the school day. Could happen anytime during the school day, really, and that would be up to the school and school board or school principal, and they'd have conversations with the parent advisory council or parent council or school committee, whatever they want. So I think this is, as the minister said, is a great idea, and I look forward to passing this amendment unanimously. A little disheartened that the minister and her colleagues, the member for Point Douglas and the member for, where's Renee from? The Minister for Advanced Ed, for the lack of me knowing exactly what constituency represents, voted down the other amendment. But that being said, it looks like we'll be passing this.
It's order. It's the Minister of Housing, Addictions, and Homelessness. That's how you refer to Minister Smith. Thank you. I've just been directed, please refer to her as the Minister of Housing, Addictions, and Homelessness. Thank you.
Chairperson.
It's challenging.
A moment, please. moving forward, can we please just, in everyone's interest, just be respectful, do our best to follow the rules, and carry on? Mr. Iwasko, would you like to continue? Mr.?
I thank you, Madam Chair. We're good to move on.
Great, thank you. Any further items for Mr. Oxenham?
Yeah, I'm just wondering, thank you, Madam Chair, you're doing a fantastic job. I just was going to ask the member from Lactabani, what specific problem this period of reflection is meant to solve? You know, given schools already have discretion to include reflective or contemplative moments under existing open exercises, I'm just wondering why we need another layer of regulation and consultation for something that can already happen freely.
Mr. Big Government over there.
Mr. Iwasko?
To Madam Chairperson, and so to the member, I'm just, you know, it's one of those things that, again, like I said, the groups that I had consulted with thought the two amendments would be very nice, as the Minister of Education had pointed out. It's an amendment to bring forward a point of reflection in the day after opening exercises. As we in the chamber as well, we have some time. We do land acknowledgements. We do opening prayer, and we do have some time for reflection as well. As the member knows, in the chamber, we've also tried to bring forward the singing of O Canada at the end of the day, and not all members of the NDP caucus practice that, and so it's unfortunate. But I look forward to the full support of the member passing forward this amendment. Thank you.
Are there any further questions? Is the committee ready for the question? The question before the committee is as follows. Moved by Minister Iwasko that Clause 10 of the bill be amended by adding the following before the proposed Section 85.1. Dispense? Shall the amendment pass? Yes. I hear a no. Thank you for your patience. All those in favor of the amendment, please say aye.
Aye.
All those in favor, all those opposed, please say nay.
Nay.
In my opinion, the nays have it. The amendment is accordingly defeated.
So now we have to do shall clause 10 pass.
Shall clause 10 pass? Shall clause 11 pass? Oh, sorry, clause 10 is accordingly passed. Shall clause 11 pass? Clause 11 is accordingly passed. Shall clauses 12 and 13 pass?
No.
Shall clause 12 pass?
Shall clause 12 pass?
Yes. Pass.
Clause 12 is accordingly passed. Shall clause 13 pass?
No.
I hear a no.
I hear a no.
So then when Minister Schmidt is ready, we just recognize her, and then we go from there.
Okay. Minister Schmidt?
Thank you. I move that Clause 13 of the bill be replaced with the following. Coming into force, royal assent, 13 sub 1, subject to subsection 2. This act comes into force on the day it receives royal assent. Coming into force September 1, 2026, 13 sub 2. Section 7 comes into force on September 1, 2026.
It has been moved by Minister Schmidt that Clause 13 of the bill be replaced with the following. Coming into force, royal assent, 13, dispense? Dispensed. The amendment is in order. The floor is open for questions. Mr. Iwasko.
Thank you, Madam Chairperson. So I'd like to ask the Minister of Education and Advanced and Early Childhood Learning. So why September 1st, 2026? Why not immediately as soon as it receives royal assent?
Minister Schmidt.
Thank you very much, Honorable Chairperson. Thank you to the member for the question, which allows me the opportunity to explain. So the reason for the general amendment is that this bill was held over. It was introduced in the spring session, as I mentioned earlier. It was one of the bills that the opposition decided to hold over and to bring to this committee for debate. So the date that was previously in the act has been surpassed, and so it's administrative generally. When we're talking about section 13.2, clause 13.2, specific to Section 7 coming into force on September 1, 2026. Section 7 is the section that deals with the policies surrounding treaty and land acknowledgements. So we felt that it was necessary to give school divisions and school administration and leadership the time to do those necessary consultations with their community, with First Nations and Indigenous leadership within their community, and to make sure that they have the time to consult with the many people that they would need to consult with to make sure that they have comprehensive and meaningful policies surrounding their land and treaty acknowledgement. So thank you for the opportunity to explain the amendment.
Mr. Uwasco.
Thank you, Madam Chairperson. So to the minister, so when you were preparing this bill to bring forward, you stated, and I know that if we look back into Hansard, the few people, and to take a visual terminology of a couple of the ministers that are on this committee on the NDP side, the minister couldn't actually repeat who she actually consulted with on this, but I'm assuming that a lot of the work that was done was ahead of time, and the school divisions were given a bit of a heads up that you were going to be doing something similar to this, so that actually gave them quite a bit of time to start working on some policies. And because this is a policy, something that the school divisions would be doing amongst many of them, so they wouldn't have to recreate the wheel with each and every school division. This is something that could have been done ahead of time, knowing that as the minister is in the majority right now and in government, that this bill would have been passing by the end of October, beginning of November of 2025. And so it's interesting that once again, it seems that collaboration, accountability, and preparedness and consultation doesn't seem to be in the purview of this education minister as she's moving forward on many things with education partners across this great province of ours. So it's unfortunate that they're going to wait till the beginning of September 2026, but I guess it is what it is. You're in government for the time being, and hopefully maybe the NDP government can get a little bit better prepared and that for the upcoming session after the following throne speech. Thank you, Madam Chairperson.
Any further? Minister Cable?
Yes.
Oh, sorry.
Sorry, it just has to go government, opposition government, so if you want to...
Can he?
It's just, it's debate.
Okay.
Minister Cable?
I just wanted to pose to the Honourable Minister, we're doing enhancements to STEM programming, enhancing science and math skills across the board. Is building a time travel machine in the near future so that having to make amendments like this wouldn't happen in the future?
Minister Schmidt?
Thank you, person, and thank you to my... Okay, sorry.
Minister Schmidt?
Thank you, Honourable Chairperson, and thank you to my honourable colleague for the question. You raise an interesting question. You're right, the advancements in STEM are rapid, and we're seeing the impacts of things like AI and other types of digital enhancements in our classrooms. So we'll see if that time machine is in the future, no pun intended. I do appreciate the opportunity to just correct the record a little bit, some of the stuff that the member from Lac de Bonnie mentioned in his debate, because I don't believe that he was listening or understood to my response to his question about the need for more time. He has, once again, he makes a regular practice of insulting my intelligence and my credibility and my professionalism. He has suggested that I have somehow lacked the opportunity to have consultation. Nothing could be further from the truth. And if he had listened to my answer, the reason why we are providing this extra time is not for school divisions to consult with me or with the department or with government. What I said was that school divisions, in order to craft meaningful treaty and land acknowledgements, have to make sure they're doing that in consultation with their community, very specifically with First Nations leadership, Indigenous leadership, elders, and other people in the community. So that's why we're giving them time. I have consulted with school divisions. I absolutely take the time to do that. We can always do better. I'm always open to consulting further. But just to correct the record, it is not with the government that school divisions require more time to consult. It's with the real important work that they need to do in consulting with the community. And it doesn't surprise me at all to hear a member of the opposition arguing for less time for consultation, because that's what I heard. I heard him say, we don't need more time, let's just go ahead, they've had enough time. And that doesn't surprise me. That is the style of their government. It was a top-down, patriarchal, paternalistic, father knows best type of government. That was Brian Pallister's style. That was Heather Stephenson's style. That is clearly the style of the member for Lac du Bonny. On this side of the House, the NDP government is open always to listening, to active engagement and dialogue, to deep and meaningful consultation, especially when we're talking about with our First Nations and Indigenous communities. So I will always advocate for more time for that consultation if what we want are real and meaningful land and treaty acknowledgements. And the one presenter bringing it back to the presenters, that's what we're here tonight for, right? We're here to listen to the community, not just from the member for Lac du Bonny and his ideological bent. We're here to listen to the community. And something that the presenter, Mr. Grant, talked about was the need to move beyond just the words of a land acknowledgement, the need to move towards really meaningful ways of engaging in that work of treaty and land acknowledgements. And so we need to give school divisions and schools the time to work with their community and to work with the elders and knowledge keepers and the leadership in their community to make sure that they are coming up with those meaningful practices. And I've seen some just absolutely incredible ones in schools across our province. And so I'm very proud of this amendment and to give school divisions the time to do that important consultation work, and we will not rush it.
Mr. Yu, one thing just before we continue, there's just been a few instances of people not directing their comments through the chair. I just remind people that all comments need to come through the chair. Mr. Uwasco.
Thank you, Madam Chairperson. And I believe if we jump in that time machine that the minister was talking about, DeLorean or whatever type of time machine she's talking about, we could actually see that I was not in any way, shape, or form have been talking down to the minister about her level of intelligence. I know that she's an educated person, and she sits in a chair now that is an absolute privilege and an honor to sit in. It is unfortunate that the minister, obviously the previous premiers, Pallister and Stevenson, seems to continue to live rent-free in her head, and that she can't get over that. But what I was saying, it was sort of one of those things where I know from being a teacher in one of our incredible school divisions in this province of ours, having the consultations that schools and school divisions are having with all of their education partners, parents, staff, guardians, First Nations communities happen on an ongoing basis. And, matter of fact, when we talk about engagement and collaboration and having those consultations with the First Nation communities, Indigenous communities. She has been the recipient of a great document called Mamatuwiswin, which I do understand that eventually she's going to move forward with duplicating that document in the early childhood learning area of her portfolio as well. So I look forward to that. And with that, Honourable Chairperson, I don't actually have any further questions. I just want to correct the record that the only one that goes offside and gets into some personal attacks is the minister herself. So with that, let's get on with it and let's pass this very important amendment that the minister's bringing forward so that school divisions can follow Bill 40 come September 1st, 2026.
Is the committee ready for the question? The question, shall the amendment pass? Shall clause 13 pass?
No,
Oh,
wait.
sorry, the amendment is accordingly defeated?
Nope.
Oh, passed, sorry. Whoa. Shall clause 13 pass as amended? Clause 13 is accordingly passed as amended. Shall the enacting clause pass? The enacting clause, oh, sorry. The enacting clause is accordingly passed. Shall the title pass? The title is accordingly passed. Shall the bill as amended be reported? Agreed. The bill shall be reported as amended. Thank you. Is there leave to take a 5-minute break? Agreed. Agreed.
So it has been agreed.
It has been agreed that we will take a 5-minute break. Thank you.
That's
Mr.
four.
Bariza would count.
Yeah, that's four.
Sit down.
Please.
1, 2, 3, 4.
Let's do it.
Committee substitutions, order please. I would like to inform the committee that under our Rule 84, bracket 2, the following membership substitution has been made for this committee effective immediately. Minister Wiebe for Minister Schmidt. MLA Bariza for Mr. Uwasko. Does the minister responsible for Bill 8 have an opening statement? Minister Wiebe.
I do. Thank you very much, Chair. Good evening. Bill 8 will create regulations prohibiting specific business types from being licensed for liquor service in certain geographic areas. Manitoba currently has 2 liquor service license categories: general, which allows entry to all, and age restricted, which prohibits minors from entering. General liquor licenses are issued to businesses such as restaurants and bars, where liquor is consumed on site. Under this general license, convenience stores can sell food for consumption in a dining area, which therefore allows them to sell liquor. I know from my own experience as a parent with kids who frequent convenience stores in our neighborhood, that they go there to buy snacks and drinks often, and they do this because these are stores that are in our neighborhood. They're close to their schools, and they're close to the community centers. Having liquor on site at a venue that children frequent simply changes the experience, and it opens the door to children being exposed to alcohol consumption in a place that's otherwise designed for them. Exposure to liquor at a young age can lead to a normalization of alcohol and an early initiation of drinking among youth. Alcohol consumption before the age of 18 can have detrimental consequences on brain development and lead to risk-taking behavior and academic decline. And keeping alcohol out of young people's hands can divert them from later having contact with the criminal justice system. This bill allows government, through regulation, to designate specific business types as unsuitable for liquor service licensing, such as convenience stores in urban areas where children tend to congregate. Business opportunities can differ between urban and rural settings, and so rural convenience stores may be the only establishments that provide liquor service in a community. So that's why we're creating regulation-making powers to limit liquor licenses only in certain areas. By doing so, we're balancing the safety of young people with flexibility for businesses across Manitoba. Thank you.
We thank the minister. Does the critic from the official opposition have an opening statement? Mrs. Robbins?
Well, we oppose Bill 8 because it will hurt small businesses in the community. The impact, the viability of convenience stores that we heard tonight have been struggling with 100 stores closing in Manitoba already. We believe consumers should have choice. And if it's okay for my children, my grandchildren, as a youth to walk into my rural store and you think that urban children are going to have issues with alcohol, do you have any evidence that shows that rural Manitoba children are being affected with alcoholism over urban kids? I would question. Okay. So I just feel that rural Manitoba, you're saying it's okay for children to frequent stores with alcohol, and it isn't going to affect them, but it will affect in an urban area. It makes no sense whatsoever. I also, where businesses locate and what kind of businesses are operating and serving alcohol should be decided, to me, by local municipalities through zoning and urban planning bylaws, and open for free market to help grow Manitoba's convenience stores in selling. The Manitoba government's still going to get the taxes from this, and just like the lady tonight, she did say that they are creating in other provinces a great amount of money towards taxation of the alcohol sold in convenience stores. And the theft is also less in the convenience stores. I know in our area, I know the owners are very protective, and there's no danger or to the public. And we don't have people securing like we do at our Manitoba liquor stores. So the problems aren't happening that way. Independent businesses take their business serious. They want to be able to have this extra revenue. And I think that this bill will hurt small businesses. Thank you.
Just a reminder to address your comments through the chair. Thank you. We thank the member. During the consideration of a bill, the enacting clause and the title are postponed until all other clauses have been considered in their proper order. Shall Clause 1 pass?
Pass.
Clause 1 is accordingly passed. Shall Clause 2 pass?
Pass.
Clause 2 is accordingly passed. Shall Clause 3 pass?
Pass.
Clause 3 is accordingly passed. Shall Clause 4 pass?
Pass.
Clause 4 is accordingly passed. Shall the enacting clause pass?
Pass.
The enacting clause is accordingly passed. Shall the title pass?
Pass.
The title is accordingly passed. Shall the bill be reported?
Agreed.
Agreed, the bill shall be reported. Thank you.
Thanks, Christian.
Does the minister responsible for Bill 12 have an opening statement?
I do.
Minister Smith.
Thank you, Honorable Chair. I want to thank all of the presenters for taking the time to come out and present, and also for those for their written submissions and their perspectives that they provided tonight for our government. Finding affordable housing is a growing challenge, not only here in Manitoba, but across the country. That's why our government is investing in housing, protecting the investments Manitobans have made in affordable housing. We believe that every Manitoban deserves a safe, secure place to call home. The purpose of Housing and Renewal Corporation Act is to ensure that Manitoba has an adequate supply of housing and that housing remains affordable for tenants with low to moderate incomes or with special needs. However, the current act does not include sufficient checks and balances to prevent the sale or transfer of buildings that have received public funding. So without these safeguards, we saw the sale of affordable housing and unaffordable rent increases under the previous government. That government sold housing. Our government is building and protecting it. So Bill 12 will protect Manitobans' public investment in affordable housing. It aligns with our government's priority to maintain and expand an adequate supply of affordable homes and to ensure that housing remains truly affordable. The sale of Lions Place, as we heard tonight, a seniors nonprofit housing complex in Manitoba, to an Alberta-based for-profit real estate company, raised serious concerns and left a lot of seniors without their community. Manitobans worry that future sales of public funded housing could lead to rent increases and loss of affordable units, and that's why this bill is important. Manitobans spoke up, and our government is listening. We know that affordable housing helps combat poverty, build safer communities, and provide stability for individuals and families. That's why Bill 12 will require that any owner of a publicly funded building must obtain prior written consent from the Manitoba Housing Renewal Corporation before selling, demolishing, or repurposing that building for anything other than social or affordable housing. Members across the way have criticized this bill, saying it will discourage investment. Well, they didn't produce not one speaker tonight to the contrary. I'll take this moment to remind the room that those same members delayed this bill in the last session, that not one developer came tonight to raise any concerns. Not one developer wrote into my office with any concerns or presented at committee. Our government continues to invest in market, social, and affordable housing, and we'll soon have more news to share about new measures, including a tax credit to support housing development. So Bill 12 strikes a careful balance between encouraging development and safeguarding the investment Manitobans have made in social and affordable housing. So under this new legislation, more than 150 existing projects representing over 5,000 rental units will be protected. All new projects receiving at least 15% of their funding from the province will also be covered. These measures will help preserve Manitoba's affordable housing stock for generations to come. And we heard how important that is from members that came and presented tonight. Bill 12 protects Manitobans and the public investments that make affordable housing possible, reaffirms our government's commitment to safe, stable, and affordable housing. So I want to thank all of the members that came and presented tonight, all of the nonprofits for their valuable and affordable housing that they provide, and for protecting taxpayers' money, unlike the former government, PC government, who sold off and failed to protect the social housing, which seniors, vulnerable seniors, or fixed incomes who had the beautiful, thriving community at Lyons Place that unfortunately was slowly dismantled by the non-protection of the Cadillac senior housing of the former government. We're not taking this approach. This bill is to ensure that Manitobans' taxpayers' monies are protected and that social and affordable housing is protected. We're very proud of this bill and the protection that it will provide for Manitobans for years and generations to come.
We thank the minister. Does the critic from the official opposition have Mr. Briza?
Thank you so much, Honorable Chair. Thank you so much, Honorable Chair. First of all, to the people that presented tonight, both with written and in person here, thank you very much for the work that's been done here. To the committee that's here, also thank you for being here tonight. Key messages is just to be clear on this is that we did have a number of developers that did come forward to us. There was concerns that if they were identified that there could be retribution against them. So that was one of the reasons for them not coming forward tonight. I will talk about some of the things that they did speak of. Some of the things with the bill is it will discourage investment in social housing. This bill will make the affordable housing crisis even worse by discouraging developers from investing in housing. This bill meddles in the real estate market and will discourage developers from creating new housing units. This bill will hurt Manitobans looking for an affordable home. The bill meddles in the real estate market and will discourage investors. The bill discourages investment in housing and social housing. This bill will discourage developers from investing because they need the province's permission to sell or divest their assets. This bill will make the affordable housing crisis even worse by discouraging investors from creating new housing units. This bill meddles in the real estate market because developers would need provincial approval to sell. The bill is bad for Manitoba families looking to purchase affordable housing. Developers will be discouraged from partnering with the government to build new housing units because the government will control whether their assets can be sold. Some of the comments that did come from some of the people that come forth to us were the consensus from the committee was the best place for this type of arrangement from the province would be each in individual funding agreements. Overall, the committee thought that 15% was too small of a funding percentage for this type of a broad prohibition. Most importantly, the committee was of the opinion that if it were to proceed, there should be a time frame or sliding scale for when prohibition expires, depending on the exact structure and scope of each project, after which the province will have seen if the social benefit and the owner would then be free from prohibition. The committee also felt that if it proceeds, there should be a way to deal with extenuating circumstances like death of an owner or bankruptcy. With the province, it gets first right of refusal on the buildings they contribute to, then if they, sorry. Then if they don't want the building sold, maybe. Sorry. Then perhaps the province could buy it and control it themselves. A healthy real estate market needs liquidity, and if the owner doesn't have control over selling the building, then there's less motivation to reinvest and maintain the asset if they can't expect to realize a return. For those wanting to hold long-term, it might not be a difference, but the proposed restriction will impair value. So again, some of these people that did speak to us are investing in social housing in other provinces currently right now. So again, we're going to propose some amendments that we think would help enhance this bill and move it forward even more. Thank you.
We thank the member. During the consideration of a bill, the enacting clause and title are postponed until all other clauses have been considered in their proper order. Shall Clause 1 pass? Pass. Clause 1 is accordingly passed. Shall Clause 2 pass?
Pass.
I hear a no.
Hold on.
Mr. Breeze.
Emily Breeze.
Mr. Breeze or MLA Breeze? No, no.
MLA Breeze.
MLA Breeze. Great.
It's late at night.
MLA Breeze, you have the floor.
Thank you. Proposed amendment to Bill 12, the Housing and Renewal Corporation Amendment Act, moved by myself, Mr. Bariza, that Clause 2 of the bill be amended in the proposed Clause 14.2, bracket 2A by striking out 15% and substituting it with 50%.
Is there leave to have the amendment considered as written?
Yes.
Yes. Continue. It has been moved by Mr. Bariza that Clause 2 of the bill be amended in the proposed dispensed. The amendment is in order. The floor is open for questions. Minister Smith.
So I'm interested to know who this committee is that the member has consulted, because we've done lots of consultation on this and spoken with lots of nonprofits. Not one person has written into our office, not one. We've met with hundreds of folks. Folks that are getting into the nonprofit housing are not getting into nonprofit housing to make money. They're getting into the nonprofit housing sector to help people. They're getting into nonprofit to support and to ensure that folks are getting out of gender-based violence, that they are getting wraparound supports, that they are families that need affordable housing. So I'm interested to hear the member where this committee is, because 15% is, strikes the right balance. It's a move in the right direction. We heard from members tonight, over 600 units were sold in just 2 transactions. Smith Street, Lyons Place. This protects, the taxpayer's purse. This ensures that investments that were made by Manitobans into social and affordable housing are kept social and affordable. So I'm not sure why members opposite want to delay this bill, why they delayed it for months. We want to make sure that folks get into housing, that they're supported, that they're not homeless, that they get the supports that they need, that they have access to safe and affordable housing. We heard members tonight talk about folks fleeing gender-based violence. We heard folks talking about seniors housing, how it was dismantled because of the lack of support of members opposite and not supporting Lions Place. So, this has been, what taxpayers have asked for, what Manitobans has asked for. They've asked us to protect social and affordable housing. And this is exactly what this bill is doing. And this strikes the right balance. And this is what 15% is what is been asked for by Manitobans.
MLA Bariza.
Thank you, Honorable Chair. Again, I will say this committee was a group of real estate developers. And again, they asked not to be named because of fear of retribution from the government. And again, that was, we feel that a true partnership is 50%. The Minister of Justice seems to think that this is a joke. This is the information that we brought forward that we got from those real estate investment developers. They're afraid of retribution, as I would be.
Any other questions?
Is the committee ready for the question?
Is the committee ready for the question?
Question.
Shall the amendment pass?
Shall the amendment pass?
No.
Yes.
No.
I hear a no. Shall clause, all those in favor of the amendments, please say aye.
Aye.
All those opposed, please say nay.
Nay.
In my opinion, the nays have it. The amendment is accordingly defeated. MLA Bariza.
Thank you, Honorable Chair. I have another amendment.
Thank you.
25%.
Can you use this one back? Right?
Yeah, we're going to wait till he
Reads it. Okay. Let's start. Mr. MLA Bariza. Oh.
That clause 2 of the bill.
MLA Bariza.
Thank you, Honorable Chair. I move that clause 2 of the bill be amended by adding the following after the proposed clause 14.2 bracket 2 A bracket A1 more than 25 years have elapsed since funding for the construction and financing of the building was last received.